Hi, good evening everyone. So today we'll discuss the questions from polity and governance for last 3 years. And again, the idea is not necessarily to give you the right answers or what is the exact content that needs to goes into those answers, but to get a broad sense of how we approach these questions and what could have been the possible way in which you could have extracted maximum marks out of the examiner in the mains examination. So as far as the polity and governance section is concerned, I think that I don't need to highlight the importance of this particular section in terms of weightage of marks. Out of 250 marks in the paper 2, almost 160 plus marks are from this section only. And not just that, but this is also important for prelims examination and a lot of other concepts in other subjects, whether it is concepts related to the areas of disaster management or internal security or ethics in paper 4 or the issues related to society. You can understand them properly if you understand polity and governance. So that is why having a good grip over this subject is really, really important. So let's start with our analysis. And I always say that one of the ways to actually understand the pattern of the examination, what the examiner is expecting, and how we should prepare ourselves for the future is to look back at the past. Often I see most of the candidates just ignoring previous year questions, and I really don't know, to me it just doesn't make any sense at all, because if you have to really begin preparation even before picking up any basic book, you must first pick up the question papers that have been asked, questions that have been asked by UPSC. If you can have an understanding of what UPSC is expecting from every topic, or what are the topics which UPSC is emphasizing on, your preparation would be way more focused. But somehow there is a very weird strategy which is followed by most of you, that you first try and cover all the topics, cover the entire syllabus, which, to be very honest, never happens. It will never happen. Many of you may have already given the prelims examination, and you must have also realized that despite all the best efforts, you would still not feel that I am 101% confident of my preparation. I'll tell you something, you would never be 100% confident of your preparation. No one ever has been in this examination, because the nature of the examination is such. The only way to be confident, the only way to overcome that anxiety, that whatever I know, is that enough or not, is to go through previous year questions and to be content that at least if UPSC asks anything like this, I would be able to answer. And to, of course, attempt some test series or some answer writing practice in a proper examination kind of a environment. That is another problem that I see. A lot of you do practice answer writing, a lot of you do practice tests as well, but you don't do it in that environment. You don't do it in that that different environment, that pressure. And that is why when you go into the examination hall in UPSC, you think that this is a completely different setting altogether. If you have to make yourself mentally ready for the exam, whether it is prelims or mains, you need to attempt tests in that kind of circumstances only. That has to be in some unknown environment. That has to be in the pressure of time. That has to be when the invigilator is moving around. That has to be when hundreds of other people are also sitting around you, and when you have those distractions. Only then you can train yourself mentally to appear in the examination conducted by UPSC. Unless you do that, you should not expect that you will do well in the examination. Anyway, so let's start with our discussion. As far as the various themes on which, or various topics from which UPSC tends to ask questions in the examination, the theme of federalism is something that we see has been the one from which UPSC has asked maximum number of questions in the examination. Even the current affairs related questions that are asked by UPSC, which we will have a look at very shortly, they are in some way or the other related to the theme of federalism. We'll see so many questions which UPSC has asked from this specific theme, which it has related to the theme of federalism. So let's have a look at some of the questions that have been asked. For example, in 2020, UPSC had asked that how far do you think cooperation, competition and confrontation has shaped the nature of federation in India? So whatever federalism that we have in India, how far is that a result of cooperation between the federal units, which could be states and center or states? How far is that a result of competition between the federal units as well as confrontation, that is conflict between the federal units? Another question which was asked in 2020 was where they had related what was there in the news, what was there in the current affairs to the theme of federalism again. So they said, Indian constitution exhibits centralizing tendencies to maintain unity and integrity of nation. We all know that Indian constitution is not federal in the traditional sense like the American constitution. We have given more powers to the center, to the union as compared to the states, and the reasons for doing that in front of the constitution makers were essentially to maintain firstly the unity and integrity of the country, because they had just come out of a partition of the country. And secondly, they also believed that the economic growth in the country could only be achieved by having a strong center, by having those institutions which are controlled by the center directly. And not just that, but even for societal reasons, for social reasons as well, to bring about a social transformation in India, to ensure the welfare of the tribals, to ensure the welfare of the scheduled castes, the minorities. We can't leave the issues completely in the hands of the states. And in that context only, it says that elucidate. So you have to explain upon this particular statement that Indian constitution has exhibited centralizing tendencies in order to maintain unity and integrity of nation. And you have to elucidate that, especially in perspective of the Epidemic Diseases Act of 1897. We know that largely public health is a state subject. But then we have the Epidemic Diseases Act of 1897, which gives extraordinary powers to the union. That is nothing but an example of centralizing tendency in the Indian constitution. Right? Similarly, to deal with disasters, we can't have, let's say if a disaster strikes multiple states in India, if there is a situation of flooding, or if there is a situation of drought in North India or in South India, or there is an epidemic which has come into place, in that case, we can't expect the states to be running left, right and center. We want them to having a uniform approach. And that could be only adopted by having a legislation made by the Parliament of India in form of Disaster Management Act. And then in form of in context of the recently passed Farms Act of 2020 as well. So what it has done is, see, the question is not about Epidemic Diseases Act. The question is not about Disaster Management Act. The question is not about farms laws. But the question is that how Indian constitution is exhibiting certain centralizing tendencies, and that you have to explain with the help of these examples. That is what the question is all about. Then there is another question. How have the recommendations of 14th Finance Commission of India enabled the states to improve their fiscal position? So there were certain path-breaking recommendations which had been made by 14th Finance Commission, and how have those recommendations helped the states in improving their fiscal position? Now, this kind of a theme of question related to Finance Commission, recommendations of Finance Commission, terms of reference of Finance Commission, impact of recommendations of Finance Commission has been one of the favorite topics of UPSC. So you can expect that there can be a question on the recommendations made by the 15th Finance Commission and what is the impact of those recommendations of 15th Finance Commission on the fiscal position of the states in India. This is something which UPSC has, at least if I am not wrong, if my memory serves me correct, they've asked at least 3 questions like this in the past. So even though maybe in your basic polity classes, we may not touch upon the recommendations of 15th Finance Commission, but then you should make it a point that I should go and read the recommendations of 15th Finance Commission. I should read some articles, newspaper editorials that have come with respect to this. You can always go back and do a bit of Google search and you will come out with a number of articles on Indian Express, Hindu, Times of India, etc., where you can extract content for your answers. Then another question which was asked was with respect to the general consent which is provided by the states to the CBI. So as you people would know, CBI is a central investigation agency, but law and order is a state subject, public order is a state subject. And if there is any investigation that is supposed to be conducted in any case, either the investigation can be performed in a criminal case, either the investigation can be performed by the state government or by the state police, or the investigation may be conducted by the CBI as well. Now, as far as the investigation to be conducted by the CBI is concerned, if we talk about investigation to be conducted by CBI, then we must also keep it in mind that the investigation by CBI cannot just be conducted on their own. They must seek the permission of the state government. For this, either the state government has to give permission on a case-to-case basis, or they may give a general consent. That in generally, whenever there is a case which arises with respect to which the CBI's investigation is required, they may investigate those particular cases. But such investigation which is conducted in general consent cases, this general consent may be withdrawn by the state governments as well. So when this question was asked in 2021, there was a lot of debate in the newspapers, there was a lot of debate in the country where some of the states controlled by the opposition had withdrawn the general consent given to the CBI. And there was a confrontation between the Chief Minister of West Bengal, the government of West Bengal, and the central government also over this particular matter. So they asked a question in that context, but again, if you look at the question, it says that the jurisdiction of the CBI regarding lodging an FIR and conducting probe within a particular state is being questioned by various states. We know this as a fact. However, the powers of the states to withhold the consent to CBI is not absolute. So the powers of the state to not give permission to the CBI to conduct investigations in their state is not absolute in nature. Explain this with special reference to the federal character of India. Again, they have brought in the theme of federalism in this current context. Another question which was asked last year, and I think this was a very, very good question, because this question requires you to think on feet in the examination. You must understand one thing. Questions which are asked by UPSC cannot be just, you can't just prepare them beforehand all the time. There will be some questions which will be tough questions. There will be some questions where you will have to apply your mind. You will have to think logically, think analytically in the examination hall. This was one of those questions. This question, because this forces you to think. This question says that while the national political parties in India favor centralization, so if you see the national political parties, whenever they are in power especially, you will see that they tend to favor centralization. They tend to favor more powers in the hands of the center. They tend to say that the center should have more discretionary powers with respect to what funds should be given to the states or not. They tend to favor the control of CBI in their hands. They tend to control, they favor the control of various enforcement agencies in their hands. They also tend to favor intervention of center in matters of states when there is a breakdown of law and order machinery in the states, whenever there are communal riots in the state. But then it says the regional parties are in favor of state autonomy. And you have to comment on this, that the regional parties are in favor of state autonomy. That is, regional parties tend to favor decentralization, tend to favor more powers to the states. But you have to comment on this. You don't have to necessarily explain this, which means that you may have a contrary viewpoint also on this topic. You may say that no, that's not true. The national parties also, in order to increase their regional presence, in order to increase their federal presence, do tend to take up local issues as well, do tend to favor decentralization at times. They try to adopt horses for courses approach, and then it's not that. The regional parties always try to favor decentralization. The regional parties as well, at times, when they have national aspirations, when they have national ambitions, they also go in favor of centralization at times. So anyway, the point that I'm trying to make is that these are some of the questions that have been asked by UPSC related to these themes, related to the theme of federalism in the recent past. Let's look at some of these questions. It won't be possible to deal with all the questions, because I've been told that if I look at the number of questions that have been asked from polity and governance section, especially in last 3 years, they number almost 36, 37 questions. So it will not be possible for me to deal with all those 36, 37 questions here in a session of, let's say, 2.5, 3 hours. For that, I would possibly need maybe 6 hours. But let's try to get some broad idea of some questions of how they can be approached. So first, let's look at this particular question. How far do you think cooperation, competition, and confrontation have shaped the nature of federation in India? Cite some recent examples to validate your answers. You have to give certain recent examples to validate your answers. This is just a 10 marker, by the way. Right? So it is saying that three areas: cooperation, competition, confrontation, how that has shaped Indian federalism, and you have to talk about certain recent examples to justify. So first, when we talk about this particular question, let me first ask you, what could be the possible way in which you can write the introduction to this particular question? Do keep it in mind that you don't have a lot in terms of your space. It's just 150 words. So if you plan your answer also, your introduction cannot be anything more than 15 to 20 words. Because if you have to explain cooperation, competition, confrontation, and even if you spend 30 words on each one of them, you would then be just left with around 40-50 words more to write the conclusion and maybe a few other things here and there. And 30 words is a very conservative thing which I am saying. You won't be able to write even one single idea properly in 30 words, maybe 2 ideas properly in 30 words. So what could be a possible introduction to this question? I am just showing you the question again. Right? The question is that how far do you think cooperation, competition, and confrontation have shaped the nature of federation in India? What could be a possible introduction to this question? And you must think, before you answer this, that I have limited number of words to write the answer to this question. So my introduction should not be generic. My introduction must be a part of the answer and must answer the question in some way. Yes? Yes. Quote, appreciating Indian parliamentary democracy. But this question is not about parliamentary democracy. This question is about federation. This question is about nature of federation in India. Yes. Which judgment of the court have you read, sir, in which it has, don't just fire in the dark, right, by just saying that we will write some recent judgment of the court in which it has talked about basic structure of the constitution and federalism as a part. Which judgment have you read, sir? Because I can't seem to recollect any specific judgment of the court in the recent past in which the Supreme Court has mentioned this specifically. Right? Yes. Can we say that India has a quasi-federal nature of... Now tell me something. When you write that India has a quasi-federal nature of polity or whatever, don't you think that almost every other candidate will be writing that? But you get my point. Can every candidate in the exam write that or not? First tell me that. Whoever is writing the mains examination, can everyone do that or not? Are you someone who's a genius who thinks that that's the only, so of course, so think differently. और थोड़ा सोचो. सोचोगे तो और मिलेगा कुछ, हाँ? Yes. India Innovation Index. Very good. Could be one of the examples. You could begin with an example only. You could begin with one of the themes of this question. That the India Innovation Index of the Niti Aayog, which ranks the states according to their capability to innovate, has highlighted the competitive nature of Indian federalism. But there are various other dimensions as well. And then you explain competition, confrontation, and the cooperation parts of Indian federalism. Very good. Yes, what else? Yes. Sorry? Hmm. 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 Okay, maybe you can mention that due to the pandemic, a lot of people, migrant labor, moved away from here and there, and there was lack of coordination, cooperation that was seen between the states in India in order to deal with that particular tragedy which had been created on the streets. Maybe you could begin that. Very good. What else? Yes. You could talk about some of the disputes. You could talk about interstate river water disputes. So to begin with, yes. Anyone else? Yes. फेडरलिज्म का कोर्ट, कैसा कोर्ट सर? कुछ भी? कौन एक्सपर्ट? ऐसे ही तुम्हें याद होगा एग्जाम के अंदर, याद करके जाएंगे हम कोर्ट फेडरलिज्म पे। मैं देखूंगा कितना याद करके जाओगे तुम फेडरलिज्म के ऊपर कोर्ट। किस किस चीज पे याद करके जाओगे? कॉन्स्टिट्यूशन पे याद करके जाओगे, फेडरलिज्म पे याद करके जाओगे, फंडामेंटल राइट्स पे याद करके जाओगे, टीपीएसपी पे याद करके जाओगे, फाइनेंस कमीशन पे याद करके जाओगे। किस किस चीज पे कोर्ट याद करके जाओगे? हाँ मेरे को बताओ तो, मैं पूछ रहा हूं, अभी पूछ रहा हूं मैं, क्या कोर्ट लिखोगे बताओ? वो चीज सोचिए जो प्रैक्टिकल हो, वो चीज सोचिए जो लिखी जा सकती हो। हवाई किले मत बनाइए कि मैं एक कोट याद करके जाऊंगा फेडरलिज्म से रिलेटेड, फिर मैं लिख डालूंगा। नहीं याद हुआ तो? नहीं याद हुआ तो क्या करोगे? छोड़ दोगे? फिर सिचुएशन तो वही तो मैं कह रहा हूं। यस, यू गेट द पॉइंट। Maybe you could begin with that SR Bommai case. Supreme Court had stated that federalism is a part of the basic structure of the constitution. Maybe you could talk about that, but again, does that answer the question? Does that answer the question? Is the question about whether federalism is a part of basic structure or not? The question is about how cooperation, competition and confrontation have shaped the nature of federation in India. So think, one could be that you pick up any recent example of confrontation, cooperation or competition and talk about it, and then talk about that there are other themes also, as I said. That could be one of the ways in which you could begin the answer to this question. See, I am here not to tell you घिसा पिटा answers that you can find at multiple places. वो आप हजारों जगह ढूंढ सकते हैं। मेरा अटेम्प्ट यह है कि आप लोग किस तरीके से फुल प्रूफ तरीके से 100 नंबर ला सकें, 100 से ऊपर ला सकें जीएस पेपर 2 में। और अगर वो सिक्योर करना है तो कुछ एक्स्ट्रा ऑर्डिनरी करना पड़ेगा। यू विल हैव टू राइट समथिंग एक्स्ट्रा ऑर्डिनरी ना, मतलब, और एक्स्ट्रा ऑर्डिनरी का मतलब नहीं कुछ मतलब बिल्कुल एकदम अद्भुत लिख दिया, दैट्स नॉट व्हाट आई एम सेइंग। बट यू विल हैव टू थिंक, यू विल हैव टू सी दैट हाउ आई कैन आंसर। और देखिए, आप बोलेंगे कि नहीं ये तो एक क्वेश्चन है, फिर अगर एग्जाम में फिर आ गया। एक बार आप सोचना शुरू करते हैं, वंस यू स्टार्ट अटेम्प्टिंग क्वेश्चंस लाइक दिस, देन यू स्टार्ट गेटिंग एन आइडिया ऑफ हाउ टू अप्रोच क्वेश्चंस। अपने आप ऑटोमेटिकली आपका दिमाग चलना स्टार्ट होता है। ऑटोमेटिकली इन एनी अदर क्वेश्चन ऑल्सो यू वुड स्टार्ट थिंकिंग, बट फर्स्ट यू हैव टू प्रेस हार्ड। फर्स्ट यू हैव टू थिंक रियली रियली डीप, एंड ओनली देन यू विल बी एबल टू थिंक ऑफ सर्टेन आइडियाज। यस, और बताइए। There is nothing like waste, sir. There are so many things that you can write. There is nothing like waste. इसमें सर रात हो जाएगी अगर मैं इस क्वेश्चन के ऊपर डिस्कशन लगा दूं तो। अभी मैं आपको कम से कम नहीं तो 10,000 वर्ड का एस्से लिख सकता हूं इस पे। तो वही तो आप कह रहे हो, वेस्ट हो जाएंगे वर्ड। पॉइंट अभी आपने, अब ये मत बोलो, 2 चीजें बोल दी आपने। सर ऐसा नहीं है ना, तो ये तो तैयारी की बात है ना, ये तो तैयारी की बात है कि 7 मिनट में जितने में पॉइंट सोच सकूंगा। अरे मेरे भाई, ये तो तुम्हें पहले से सोच के जाना चाहिए ना कि क्या कंपटीशन नहीं है स्टेट्स में, क्या कन्फ्रंटेशन की बात नहीं है। कन्फ्रंटेशन के कितने पॉइंट्स हैं सर? लैक ऑफ कोऑपरेशन, लैक ऑफ कोऑपरेशन के कितने पॉइंट्स हैं? आप सोचिए तो, एक बार अपना दिमाग घुमाइएगा जरा। टेररिज्म, क्लाइमेट चेंज, वाटर क्राइसिस, जीएसटी, नक्सलिज्म, इंसर्जेंसी, एक चीज थोड़ी ना है सर. टैक्सेशन, कोऑपरेशन से रिलेटेड 50 पॉइंट मिल जाएंगे सर. इंटरस्टेट रिवर वाटर डिस्प्यूट्स, सो मेनी थिंग्स आर देयर. ऐसा नहीं है आप ऐसा सोच रहे हैं, मैं वही बोल रहा हूं. देयर इज अ लॉट टू राइट. मैं आपको गारंटी से कह रहा हूं, अगर आप ढंग से तैयारी करें, इश्यूज पढ़ें, न्यूज़पेपर्स पढ़ें, आपके पास 10,000 वर्ड लिखने को होंगे सिर्फ इसी टॉपिक पे. सो दिस इज लैक ऑफ प्रिपरेशन, वेर यू आर थिंकिंग कि नहीं मेरा एक पॉइंट वेस्ट हो जाएगा इसमें. बहुत कुछ है सर लिखने को. देयर इज अ लॉट टू राइट. एंड सी अगेन द पॉइंट दैट आई एम ट्राइंग टू मेक इज, हाउ डू यू एंश्योर दैट योर इंट्रोडक्शन इज नॉट सेपरेट फ्रॉम द आंसर. Most of the times the introductions which you people write are not a part of the answer. They are not related to the question. They are just generic introductions. India is a federal polity, so India's polity is of quasi-federal nature, so that is not answering this question. It is not answering this question. You get my point? There could be another way. You think like this. If I were in your place, I could have possibly written this, that constitution makers had imagined that there would be a number of conflicts that would emerge between the states in India. Therefore, there are a number of mechanisms included in the Indian constitution on this. Yet at the same time, there are other important themes as a part of Indian Federation as well. Some of which are as follows. And then you could have talked about the cooperation part. You could have talked about Article 263 of the Constitution. Yes. You could have talked about how the states have cooperated with each other when it comes to various multi-purpose projects, various dams, developmental projects that have come up in India. In case of competition, you could have talked about these indices of Niti Aayog. You could have talked about the states competing with each other to attract investments, labor reforms, states trying to make themselves an attractive destination for investment. You could have mentioned about that. In confrontation, you could have mentioned about interstate river water disputes. You could have mentioned about approach towards dealing with law and order problems such as Naxalism. You could have talked about boundary disputes. So many things to talk about. Believe me, ज्यादा नहीं लिख पाएंगे आप, एक दो पॉइंट ही लिख पाएंगे. सच्चाई तो ये है, बिकॉज यू डोंट हैव एनफ टू राइट. सो एनीवे, लेट्स कम टू दिस क्वेश्चन. सो लेट्स से इफ वी वर राइटिंग द आंसर टू दिस पर्टिकुलर क्वेश्चन, इन द इंट्रोडक्शन यू कुड हैव टेकन अप एनी वन थीम. दैट कुड हैव बीन confrontation, cooperation, competition, etc. And you could have helped that, explain that with the help of a recent example. Once you had mentioned about that one particular theme, maybe, see, one way was that you could have just continued to explain that theme only. Continued with the same theme. Or the second approach could have been that you straight away jump to other themes and this theme as well. दोनों तरीके से कर सकते हैं. क्वेश्चन आंसर करना ऑब्जेक्टिव है, इंट्रोडक्शन लिखना ऑब्जेक्टिव नहीं है. बहुत सारे लोगों को ऐसा लगता है नहीं इंट्रोडक्शन होनी ही चाहिए, कंक्लूजन होना ही चाहिए. एग्जामिनर ऐसे नहीं देख रहा है आपके आंसर को, वो देख रहा है कि आंसर कितने, क्वेश्चन कितने अच्छे से आंसर हुआ है. अब तू इंट्रोडक्शन लिख या मत लिख. अगर तेरी इंट्रोडक्शन मेरे को बोल रही है इंडिया इज अ ग्रेट पार्लियामेंट्री डेमोक्रेसी, तो क्या हो गया? हाउ डज इट मेक एनी डिफरेंस टू द आंसर? हाउ डज इट मेक एनी डिफरेंस टू द थीम ऑफ द क्वेश्चन? ये सोचिएगा इसके ऊपर, ट्राई टू थिंक ऑफ इट. एनीवे, so now once you had mentioned about one theme, say for example you had mentioned about the theme of competition, which our friend here talked about, that I could have mentioned about the India Innovation Index, right? I would have mentioned about the India Innovation Index of Niti Aayog, और मैं उसके बारे में लिख देता. Then I could have possibly expanded a bit more on competition. In competition as a theme, I could have mentioned about possibly the investment summits which are conducted by the states in order to attract investors. This is also a theme of competition between the states. Secondly, you could have mentioned here
about how the states are competing with each other, again, to introduce various reforms, labor reforms, various other legislative reforms. Could have mentioned about that. Then, if we talk about the theme of confrontation, in confrontation, you could have talked about interstate river water disputes, where you could have possibly mentioned about the Kaveri dispute. You could have mentioned about interstate water disputes. Then you could have possibly talked about conflicts with respect to dealing with Naxalism, where there has been a tussle between the states, the state police department, where they believe that they are not ready to share intelligence with each other. You could have mentioned that. In confrontation, you could have mentioned about boundary disputes. So many boundary disputes that we know exist between states in India, whether it is Maharashtra or Karnataka, whether it is Assam or Mizoram. You could have mentioned about that also. You could have mentioned about taxation, movement of interstate vehicles, interstate goods, services. That could have been another theme of confrontation. Then you could have mentioned about cooperation. And see, here it is also important, wherever you find some provisions of the constitution which are relevant, you could mention those as well. So, cooperation, you could have mentioned about the revival of the Interstate Council, Article 263. You could have talked about the formation and the working of the Niti Aayog Council. Again, an example of cooperation, right? In cooperation, you could have talked about that how the states have often come together to help each other in combating crimes such as terrorism. You could have talked about states coming together in form of GST Council, aiding each other and forming a collective opinion on behalf of the states. So many things are there to talk about in this. Now, once you have mentioned and done this bit of analysis, if you go back to the question again, the question is saying that how far do you think cooperation, competition, confrontation have shaped the nature of federation in India? Give some recent examples. So you have explained how far there has been competition as well, cooperation as well, confrontation as well. Now see, you don't need to necessarily think only in context of India here. You may also draw an example from somewhere else also. You may draw example of United States of America in your conclusion, that how possibly the states in United States of America have gone on to form various regional bodies to promote cooperation amongst themselves. And you could have said that we possibly may need to adopt the same kind of principle in India as well. You could have talked about that how maybe in the past confrontation and competition were the themes, but since ultimately we all are one nation, it is important to promote cooperation between the states on various issues which are affecting the citizens of the country, which could be again climate change, disaster management, etc. So you could have ended the answer like that. Or maybe you could have talked about revival of the Interstate Council, because that is one constitutional mechanism that has been created with the idea of promoting cooperation between the states. Or you could have talked about that how going ahead in future, the center should try to bring all the states together on the same platforms through Niti Aayog, through the Interstate Council, in order to discuss and deliberate over issues which are common to all the states in India. So that could have been another conclusion which could have been given. So you have to think, the point that I am trying to say is that question is fairly simple. Everyone can write the answer to this question. The challenge which lies is that which points to write and which ones to miss. Which ones not to write and which ones to write. That is where the real challenge comes in. And all of this has to be done within 8 minutes. right? Yes, you had a question. Possibly. That is also one interpretation. And when I discussed this question in the past as well, I did take up that point as well. And you are absolutely correct. He's saying that his examiner is saying nature of federation. Does that mean that we possibly need to trace how the nature of federation has changed? Earlier, it was focused on cooperation, but cooperation between center and states, and then it created over some point of time we started to see more and more confrontation between union and states from the perspective of the issues over governor's appointment, imposition of Article 356 in the states, etc. And then we talk about competition, which is now emerging between the states, the units of federal setup. Possible. That is a second interpretation to this question, and you could write it temporally as well. That from 1950 to 1967, it was a kind of federalism where cooperation was the main theme. Why? Because there was same party ruling at the center in the states. 67 to 1990s, we witnessed the era of confrontational federalism in India, between the states trying to assert their own identity and fighting over various issues. And from there onwards, we have seen the era of competitive federalism. You can write that also. You may take that approach as well. The question is so open-ended that it's very difficult to tell whether the examiner is specifically talking about the temporal aspect or whether he's talking about but my understanding is, I'll just come to you. My understanding of this question is, because he says give some recent examples to validate your answer, I think he's not talking of temporal variation in the nature of federalism. Rather, he's talking about some recent examples of confrontation, competition and cooperation between the states that reflect the nature of the Indian federalism. एक तरीका इस आंसर की इंट्रोडक्शन का ये भी हो सकता था, that you could have said that in India, the way the division of the powers has been done between the states, because we have such a long list of state subject, it is bound to happen that the states will have different ideas on how to govern, and that may lead to confrontation, but at the same time that requires cooperation as well. So that could also be a possible way to introduce this particular question, drawing from the theme of constitution. Yes. I would say competition. I would say that you should show the futuristic perspective to the examiner also. क्वाजी फेडरल तो बात हो ही नहीं रही ना, फेडरल क्वाजी फेडरल बात नहीं हो रही ना सर यहाँ पे. कॉम्पिटिटिव फेडरलिज्म के एरा में रह रहे हैं हम, ऑफ कोर्स, अगर हम स्टेट्स के बीच में देखें. बट ऐसा नहीं है कि यू कैन कंप्लीटली रूल आउट कन्फ्रंटेशन और यू कैन कंप्लीटली रूल आउट कोऑपरेशन. ऑल द थ्री थीम्स आर देयर, बट if I were in your place, towards the end I would talk about that what is actually needed of these three is cooperation. That is why I was saying that states need to come together, center needs to get them together, etc., and all of those things. Is that clear to everyone? Right? Yes. Yes, of course, why not? How states and center cooperated with each other during COVID-19, etc. Yes, why not? Yes, of course. Yes, 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 yes. In what sense? Huh. No, it is not. It is not. You did not hear my entire introduction, no sir. I said that in India, competition or confrontation has been one of the main themes between the federation, the units of federation, but there are other themes as well. So isn't that complete? Oh sir, you are then if you write India is, फिर क्या लिखोगे बताओ मुझे, क्या लिखोगे? आपको यही तो मैं कह रहा हूं आपको, आप लोगों को पता नहीं किसने बता दिया कि इंट्रोडक्शन एक अलग चीज होनी चाहिए और आंसर को अलग होना चाहिए. मतलब इंसान का सर अलग हो और उसकी बॉडी अलग हो. सर बॉडी का ही पार्ट है सर. तो जब आप आंसर लिखें तो योर आंसर हैज टू एक्सप्लेन द क्वेश्चन एंड इट हैज टू फोकस ऑन आंसरिंग द क्वेश्चन. जब आपके पास स्पेशली 150 वर्ड हैं तो आपके पास ये स्कोप नहीं है बीटिंग अराउंड द बुश कि इंडिया इज अ क्वाजी फेडरल सेटअप, ये वो ढीकन फलान की उधर उधर की बातें. क्वेश्चन पे आइए, सीधा सीधा क्वेश्चन को अटैक कीजिए और उसी के अंदर आप ये सब चीजें एड्रेस कर सकते हैं. सर ऐसा नहीं है. सर वही अगेन ना, यू थिंक दैट बॉडी एंड इंट्रोडक्शन आर डिफरेंट. आई डोंट थिंक. इज योर हेड डिफरेंट फ्रॉम योर बॉडी? यू फर्स्ट टेल मी दैट. When someone meets you, does someone greets your stomach? No. What do they greet? Your face. So is your face different from your body? No. I really don't know who has told you this, that introduction and then body. This is a wrong approach in itself. Introduction has to be the part of the answer. It has to answer the question. You people have got into this mindset somehow that first introduction, then body, then conclusion. I am saying your entire answer should answer the question. Now to do hell with body, to do hell with introduction and conclusion. That is what I am saying, sir. अगर आप उस तरीके से अप्रोच करेंगे ना चीज को, तो आप 150 वर्ड के क्वेश्चन को टैकल बेटर कर पाएंगे. वरना 250 वर्ड में तो ठीक है, चलेगा ये अप्रोच. जो 10 नंबर का क्वेश्चन है उसमें आप डेफिनेटली वर्ड लिमिट एक्सीड करेंगे, क्योंकि आप इंट्रोडक्शन और कंक्लूजन को एक अलग चीज मान के चल रहे हैं एज कंपेयर टू द आंसर इटसेल्फ. आप ये थोड़ी ना कह सकते हैं बॉडी में ही आंसर लिखा है मेरा सारा, इंट्रोडक्शन क्या है फिर? यू गेट द पॉइंट. सोचिएगा एक बार, थिंक अबाउट इट व्हाट आई एम सेइंग एंड देन सी इफ आई एम राइट और नॉट. Sir, I don't know who's recommending to you what. I am simply telling you what makes sense. You tell me what I am saying is right. मैं sensible बात बोल रहा हूं कि नहीं, आप मुझे बता दो बस. कौन क्या बोल रहा है मुझे नहीं पता. कौन कह रहा है कि पहले इंट्रोडक्शन लिख डालो, उसमें कोई सर पैर ना हो. मतलब सर किसी और का, बॉडी किसी और की, ये थोड़ी ना चाहिए सर. सर किसी और का, बॉडी किसी और की नहीं चाहिए सर. हमें सर भी उसी का है और बॉडी भी उसी इंसान की है. तो आंसर के अंदर क्या फर्क पड़ता है कि इंट्रोडक्शन क्या है और कंक्लूजन क्या है? आंसर होना चाहिए ना क्वेश्चन सर. यस और नो. मैं अगर सेंसिबल बात नहीं कर रहा हूं तो मुझे बताइए. अलग से इंट्रोडक्शन लिख डाली, केसी वेयर सेड इंडिया इज अ फेडरल पॉलिटी, इज अ क्वाजी फेडरल पॉलिटी. एग्जामिनर बोलेगा भाई ये क्या है? सवाल पूछा है कन्फ्रंटेशन, कॉम्पिटिशन एंड कोऑपरेशन शेपिंग इंडियन फेडरेशन, और तुम बता रहे हो क्वाजी फेडरल है. क्या करूं मैं इस बात का? What do I do with this? रैंडम कुछ भी इंट्रोडक्शन लिखने. देखिए मैं आपको ये बात बता रहा हूं, हो सकता है आपको टॉपर कॉपीज में वैसे आंसर मिले, पर क्या टॉपर के 150 नंबर आ रहे हैं 250 में से? नहीं ना. यू गेट व्हाट आई एम ट्राइंग टू से. देयर इज, उस लिमिट को भी ब्रीच करने का तरीका है सर. जो टॉपर ला रहा है उसको भी ब्रीच कर सकते हैं आप, अगर आप ढंग की अप्रोच अडॉप्ट करें तो. ये एग्जाम एब्सोल्यूट नहीं है. मैं आपको एब्सोल्यूट लेवल पे ऊपर ले जाने की कोशिश कर रहा हूं. रिलेटिव में टॉपर का आंसर बेस्ट है आउट ऑफ 1000 आंसर कॉपीज, पर क्या वो बेस्ट आंसर ही है, आइडियल ही है? नहीं ना. दैट्स व्हाट आई एम सेइंग. दैट इज व्हाट आई एम सेइंग. दैट इज व्हाट आई बिगैन माय क्लास टुडे, सेशन विद टुडे, दैट आई एम नॉट हियर टू टेल यू दैट व्हाट इज द कंटेंट. कंटेंट आप लोग देखिए बहुत समझदार हैं, आप सब लोग पढ़े लिखे लोग हैं, आप सबके पास मटेरियल है, किताबें हैं, हजारों तरीके की यूट्यूब वीडियोस हैं. यू कैन गेट दैट. व्हाट आई एम टॉकिंग अबाउट इज द अप्रोच टू क्वेश्चंस. लेट्स लुक एट 1 or 2 more questions from this. ये वाला तो देखिए, अब this is simple question है ना. How have the recommendations of the 14th Finance Commission enabled the states to improve their fiscal position? If we look at second question, this is a very good question. Indian constitution exhibits centralizing tendencies to maintain unity and integrity of the nation. अब इसी बात को एक्सप्लेन करना है. India's constitution has given more powers to the center as compared to the states. For what reason? To maintain unity and integrity of nation. You have to elucidate in perspective of these three laws. So when you begin your answer, again here the main theme of the question is that India is a setup in which union is more powerful than the states. Why? To maintain unity and integrity of nation. Indian constitution includes several provisions that give more powers to the union as compared to the states. For example, the appointment of the governors and important constitutional positions, the powers to impose emergency under 352, 356, 360, the powers of the union to legislate on the state subjects, the powers of the union to reorganize the boundaries of the state. This was done by the constitution makers considering the circumstances prevalent at the time of writing the constitution, which included a recently concluded partition of the country. This theme of maintaining unity, integrity of the nation can be seen in some of the recent examples as well. For example, to tackle the problem of COVID-19, the center invoked the provisions under Epidemic Diseases Act of 1897, which allows the union to have a common approach to deal with an epidemic disease, an epidemic such as COVID-19. It requires massive mobilization of the machinery on different fronts in India. And considering that we have such wide diversity in the country, such wide geography, it would not be possible for the states to lead on this front. That is why this. Then you explain in context of the NDMA, then you explain in context of the farm laws. You went from the theme of Indian constitution having centralizing tendencies and why centralizing tendencies to specific examples in the recent times. That is what the answer is demanding. But then you would say towards the conclusion that even though we have adopted a centralizing tendency, but in the recent times there has been a move towards making the power decentralized. You may give some examples. You may talk about Panchayati Raj only, but you may also talk about other themes of how we are empowering the states in India. For example, the recommendations of 14th Finance Commission that have given more share to the states from the central pool of taxes, divisible pool of taxes, from 32% to 42%, giving them more fiscal space. Reduction in number of centrally sponsored schemes to give more flexibility to the states. You get the point that I am trying to make. Whatever जो मैंने अभी आपको बोला यही है आंसर इसका. See, there can be other ways also of writing this. आप फिर वही क्वाजी फेडरल में ले जाइए बात और वो सब वहां से भी कर सकते हैं. But again, think कि how can I make my answer different? You may say that federations are usually created with strong states and weak center, as in the case of United States of America. But India has adopted a different setup because of the concerns of the constitution makers due to the reasons of partition. They feared that the nation may be broken down into various parts. In order to do this, there are certain provisions in the constitution. Give 3, 4, 5 of those provisions. वो लिख डालिए. Reorganization of states, appointment of important constitutional positions, emergency provisions, more powers in the hands of the center as compared to the states in fiscal, financial, executive matters. Once you have written that, and then you say, recently we can see this in example of this. Because see, you must understand one thing. इस क्वेश्चन में आप कितनी भी तैयारी करके जाइएगा, आप एपिडेमिक डिजीजेज एक्ट, एनडीएमए और फार्म्स एक्ट तीनों के ऊपर फेडरलिज्म के कॉन्टेक्स्ट में बहुत लंबी लंबी चीजें लिख दें, पॉसिबल नहीं है, ज्यादा कंटेंट नहीं होगा. सो देन यू हैव टू फ्रेम योर आंसर इन सच अ मैनर that I address the question, yet at the same time I also talk about the specifics that the examiner wants me to talk about. हमेशा जब भी आंसर लिखें सोचिएगा कि क्या मैं, देखिए इसीलिए मैं हमेशा कहता हूं कि सिलेबस रट लीजिए. आप रटते कुछ और हैं, रटने की चीज एक्चुअली सिलेबस है. क्यों? जब भी आप आंसर लिखें सिलेबस आपके दिमाग में घूमना चाहिए कि मैं सिलेबस से क्या लिख सकता हूं, सिलेबस से क्या लिख सकता हूं. लेट मी थिंक, हाउ कैन आई यूज सिलेबस एज अ गाइड टू राइट सम डायमेंशन. कंपैरिजन ऑफ कॉन्स्टिट्यूशन इज अ थीम, इज अ पार्ट ऑफ द सिलेबस. आप वहीं से बिगिन कीजिए. एग्जामिनर विल बी सुपर इंप्रेस्ड कि ओके, ही इज कंपेयर टू बिगिन द आंसर इटसेल्फ देयर इज अ कंपैरिजन व्हिच इज कमिंग इन बिटवीन दैट हाउ फेडरेशंस यूजुअली आर एंड हाउ इंडियन फेडरेशन इज. राइट, सो यू हैव टू थिंक. क्वेश्चन डिफिकल्ट नहीं है. देखिए क्वेश्चन मैं आपको बता रहा हूं, एग्जामिनर बहुत बार लोगों को लगता है पॉइंट्स कितने लिखे हैं उस पर जज कर रहा है, वो उस पर नहीं जज कर रहा है. एग्जामिनर इस पे जज करता है कि आपने क्वेश्चन कितना अच्छा समझा है. प्रीलिम्स में देख लीजिएगा आप वो क्या कर रहा है. इज ही जजिंग यू ऑन नॉलेज? ही इज ट्राइंग टू जज यू ऑन वेदर यू हैव रेड द क्वेश्चन प्रॉपर्ली और नॉट. मनी बिल और फाइनेंस बिल, तुमने फाइनेंशियल बिल पढ़ लिया, गलत, पूरा क्वेश्चन गड़बड़, गॉन. दैट इज व्हाट द एग्जामिनर इज चेकिंग यू ऑन. आपकी पढ़ने की एबिलिटी भी बड़ी स्ट्रांग होनी चाहिए, ऑब्जर्व करने की कि एग्जैक्टली वो एक्सपेक्ट क्या कर रहा है. एंड देन आफ्टर दैट दिस क्वेश्चन बिकम्स वेरी इजी गाइस, वंस यू अंडरस्टैंड दैट द थीम ऑफ द. अब इसको क्वेश्चन को देखकर बड़े सारे कैंडिडेट्स की हालत टाइट हो गई, उनकी हवा निकल गई कि ये क्या पूछ लिया, एपिडेमिक डिजीज एक्ट, डिजास्टर मैनेजमेंट. अरे पहले तो पढ़ो क्या लिखा है. वो बस ये कह रहा है इंडियन कॉन्स्टिट्यूशन एग्जिबिट्स सेंट्रलाइजिंग टेंडेंसीज. यू हैव टू एल्यूसिडेट. एंड व्हाई डज इट एग्जिबिट सेंट्रलाइजिंग टेंडेंसीज? टू मेंटेन यूनिटी एंड इंटीग्रिटी ऑफ नेशन. आप एग्जाम्पल भी दे सकते हो रिसेंट से, दैट व्हेन द सेंटर सेंड्स इट्स सेंट्रल आर्म पुलिस फोर्सेस टू द स्टेट्स for protection of the internal or for to prevent internal disturbance in the states, that is the centralizing tendency of the Indian constitution to maintain the unity and integrity of nation. Why is it that we have Assam Rifles in Assam, which is controlled by the center and not by the states? Why is it that we have CRPF in Dantewada, which is controlled by the center and not by the states, to maintain the unity and integrity of the nation? तो आपको जरूरी नहीं है इस तक ही सीमित रखना है अपने को. ये तो उसने इन पर्सपेक्टिव ऑफ दिस बोला है. अब जितना आपके पास पर्सपेक्टिव है दे दीजिए. रेस्ट यू राइट अ फ्यू अदर थिंग्स. अगेन थिंक व्हाट आर द टॉपिक्स ऑफ द सिलेबस. राइट, सो मोमेंट इंटरनल सिक्योरिटी कम्स टू योर माइंड, यू कैन राइट अबाउट पॉसिबली इंसर्जेंसी और नक्सलिज्म. द मोमेंट you think about disaster management, you could write something related to that. So you have to think like that. Most of the candidates don't use the syllabus. अगर आप सिलेबस को रट के जाएं लिटरली, और उसके लिए आपको ज्यादा कुछ नहीं करना है, कम से कम नहीं तो 5-10 दिन रोज सिलेबस खोल के देखिएगा. ये क्वेश्चंस मुश्किल हैं इसलिए क्योंकि इनको समझना बस सबसे इंपॉर्टेंट चीज है. रेस्ट आफ्टर दैट दे आर वेरी इजी. डू यू गेट द सेंस ऑफ व्हाट आई एम ट्राइंग टू से? सी इफ यू हैव सीन, मैंने पिछले 2 सेशंस में भी, एथिक्स में भी और इंटरनल सिक्योरिटी में भी आपको बार बार एक ही चीज बोली, दैट डोंट रन आफ्टर कि मेरे को इसमें नॉलेज क्या दिखानी है. उसको पता है नॉलेज है तुम्हारे पास, वो देखना चाहता है तुम्हारी सोच, wants to see through your thinking. along with your knowledge. That is what the examiner is interested in. लोग सिर्फ knowledge दिखाने में लगे हुए हैं उसको. मैं point लिख देता हूं 10. Doesn't work, doesn't make a difference. See, you may secure marks by writing that kind of general stuff as well. But I am here to talk about how you can genuinely score really good marks. And for that you need to understand what the question is asking. Is that clear? Yes, any doubt still here? Can we proceed further? Yes. But 14th Finance Commission recommendations were path breaking. Reason for that is 32% to 42%. Reason for that is number of CSS were pruned down. The reason for that is progressive criteria for devolution of taxes or funds.
I understand it might impact me. So let's say I start preparing this year. I wouldn't know, right, that 14 Finance Commission.
No, I don't think so. See, the 14th Finance Commission question, yes, of course the 14th Finance Commission recommendations came in 2014. But when you read, जब आप पढ़ रहे थे, जब 2020-21 का एग्जाम आप देने गए, तो आपको ये एवोल्यूशन पढ़ना जरूरी है कि स्टेट की फिजिकल पोजीशन क्या है. और वो 14th फाइनेंस कमीशन का एक बहुत पाथ ब्रेकिंग था. और उसके अलावा दूसरी बात सर, न्यूज़पेपर में बहुत सारे आर्टिकल्स आए थे इसके रिलेटेड उस साल. यस, नंबर ऑफ, बिकॉज 15th फाइनेंस कमीशन फॉर्म हुई थी और जो भी आर्टिकल्स आए थे वो 14th की बात कर रहे थे कि 14th ने ऐसा ऐसा किया तो 15th में भी कुछ इसके और फर्दर और होना चाहिए. सो इट वाज नॉट लाइक कि एकदम आउट ऑफ द ब्लू यूपीएससी ने कुछ भी पूछ लिया, ऐसा नहीं है. ठीक है, तो डजंट मीन दैट यू नीड टू गो बैक एंड नाउ रीड 12th फाइनेंस कमीशन रिकमेंडेशंस, डजंट मीन 13th, बट यू शुड नो अ जनरल, यू शुड हैव अ जनरल आइडिया ऑल्सो. एंड प्लस अगर आप न्यूज़पेपर्स पढ़ते हैं, मैं गारंटी से कह रहा हूं ये पता होता आपको 101%. आपको 3-4 पॉइंट पता होते हैं इसमें. Is this clear? Now let's move further. The jurisdiction of CBI regarding lodging in FIR and conducting probe with a particular state is being questioned by various states. However, the power of the states to withhold consent to CBI is not absolute, explained with special reference to federal character of India. So one simple introduction could be that you just talk about the nature and the work of CBI and you begin from there. Another could be that you talk about, in this question you could have talked about the confrontation that took place between the CBI and the West Bengal government over giving of sanction to investigate certain matters in the state of West Bengal. So let's say if I were in your position, I would have said that recently there was a spat observed publicly between the CBI and the state government of West Bengal over the consent or withdrawal of consent with respect to the investigation of this particular investigating agency in the state of West Bengal. This has thrown up a number of questions over whether the CBI can investigate without the approval of the states or not. फिर आप उसका एनालाइज करते. The CBI has powers to investigate the offenses committed in a state either on a one-to-one case-to-case basis, approval given by the state government, or on the basis of a general consent which is given by the state government, which can be used by the CBI for all the other matters. Some of the states have withdrawn this consent from the given to the states, to the center, to the CBI in the recent past, and on that basis they have contended that the CBI cannot investigate in their states. But there is another dimension to this, but that is not completely true. When a matter involves a case of investigation against a central government officer, the CBI has complete powers to investigate that, irrespective of whether the consent has been given by the state or not. When a matter concerns any such issue which concerns the union list, the CBI has complete powers to investigate that matter without the consent of the states. अब जब आपने ये लिख दिया, आप देखिए, explain with special reference to federal character. the states contend that they do not have the powers to investigate without the consent of the states because public order is a state subject. But a number of subjects under the union list and the concurrent list are closely related to the state subjects as well. For example, you may talk about terrorism, or you may talk about Naxalism, you may talk about some economic offense which impacts a large part of India, and that may have originated in West Bengal. In that case, of course, the states would be incorrect to keep the CBI out. The concerns of the state possibly emerge from the excessive control of center over the CBI. Therefore, there is a need to bring reforms in the functioning of the CBI so that the states are more confident of its independence and are also not wary of its misuse by the center. Some of these reforms could be 1, 2, 3, 4. एक तरीका ये है, नहीं तो दूसरा तरीका ये है कि जो भी आपने जिस तरीके से भी आपने इंट्रोड्यूस किया, सीबीआई की पावर्स बताते हुए इंट्रोड्यूस किया या आपने रीसेंट एग्जाम्पल देते हुए इंट्रोड्यूस किया, आप फिर आर्ग्यूमेंट्स गिवन बाय स्टेट लिख दीजिएगा. आर्ग्यूमेंट्स गिवन बाय स्टेट टू विड्रॉ द कंसेंट गिवन टू सीबीआई एंड द आर्ग्यूमेंट्स गिवन टू जस्टिफाई देयर पोजीशन. So possibly, let's say in this question, you could, if once you had given the introduction, right, once you had mentioned about that, तो आप पहले लिख देते recent spat के बारे में, फिर आप लिखते कि इससे इशू इमर्ज हुआ है, states have contended that CBI is acting out of its jurisdiction. The state's justification for this, you will write that. States justify that under section 5, section 6 of DSPE Act, we have withdrawn the general consent given to the states, given to the CBI. You may talk about the state's justification is that public order is a state subject and center has no business to interfere in such matters. States give a justification that CBI is a parrot in the hands of the union, and its powers are misused by the states, by the center. It is used to harass the states. कुछ जस्टिफिकेशन लिख दी, देन यू से, फिर आप अपना एनालिसिस दीजिए. बट वन मस्ट नॉट फॉरगेट दैट द सीबीआई, तो फिर आप वो बट वाले पॉइंट से स्टार्ट कीजिएगा. देखिए, मैं जब भी कहता हूं ना, बहुत सारे लोगों की क्वेश्चंस अटेम्प्ट करें, अगर आप आंसर नहीं भी लिख रहे हैं तो एटलीस्ट इतना स्ट्रक्चर लिखिएगा प्रैक्टिस के लिए. अगर आप ये भी नहीं लिख रहे हैं तो बाय बाय कह दीजिए इस एग्जाम को, से टाटा, क्योंकि नहीं होगा. क्योंकि आप इतनी भी प्रैक्टिस नहीं कर रहे हैं तो फिर नहीं होगा तो फिर वो क्या है, जुआ है. जिंदगी जुआ है, खेलो, जीत जाओ तो जीत जाओ, हार जाओ तो हार जाओ. मैं जुआ नहीं खिलवा रहा यहां पे. आई एम टेलिंग यू व्हाट इज द प्रॉपर वे टू एक्चुअली डू वेल. सो नाउ once you have mentioned all of this, then you mention what is the true picture, that if there is a case which is involving a union officer, then CBI does not need consent, doesn't need consent. You may also talk about that if a case involves something which relates to union list, then there is no consent that is required. अगर आपको कोई कोर्ट की जजमेंट पता हो तो बहुत अच्छी बात है, नहीं पता है तो नहीं पता है, ठीक है. There have been some judgments of the court also on this particular matter. Anyway, once you mention this, then you must come. अब देखिए इसी के अंदर ना यही explain करते करते, if I will show you, this will take 15 to 20 words, this will take again some 10 words, then 20 30 40 have gone here already, 1 2 3 10 12 words each, 50 words gone, 80 words gone. This again it would take your again 30 40 words, so 120 140 words are already gone, so you don't have a lot here. अब वो आ रहा है in context of federalism. So you say that indeed public order is a state subject, but at the same time we must keep in mind that there are certain issues which cannot be dealt by the states alone, and for that the role of the center also becomes very important. No doubt that the Indian constitution must have placed the subject of public order under the states, but in certain areas states intervention is seminal. Say for example in case of investigation related to terrorism or some economic offense which is affecting the entire country, कुछ एक दो आप एग्जाम्पल दे दीजिएगा. Once you have mentioned that, फिर आप इस पैट को रिजॉल्व करने का तरीका बताइए लास्ट के 40-50 वर्ड्स में. That is what is required in this answer. You get the point? कोई बहुत ज्यादा रॉकेट साइंस की जरूरत नहीं है. स्पेसिफिक्स नहीं भी पता है तो भी चलेगा. The examiner just wants to see how you think. That's all. Is this clear? Can we move further? Now, let's look at some other questions as well, because we've spent quite a lot of time on this only. So, this question was asked last year. For these questions which were asked in 2022, because I had done this analysis last year itself, I've also gotten that what was the theme or what was the reason because of which UPSC, what was the inspiration for that question as well. I've done this discussion already last year's analysis, but because ये पहली मेहनत हो रखी थी, तो I thought that why not use this. So this question we have already seen. While the national parties in India favor centralization, the regional parties are in favor of state autonomy. Comment 2022 का एक question था. अब देखिए, there were actually a number of articles which had come in the newspaper in the Hindu. ये 2020 का आर्टिकल है, देख लीजिए आप. मैं अपने आप से मन तो बना के डेट नहीं लिख के लाऊंगा. 19th of December 2020. Regional identity is ignored by the national parties. This was a statement that had been made by the Chief Minister of Odisha, where he is talking about that the BJP has launched he launched an attack on the national parties, including the BJP, and saying that they are not paying attention to the problems of the states. There was an article that had come in February 14, 2022. तो वो तो देखिए थोड़ा पुराना था, बट ये तो बिल्कुल recent था. Center State Relations, center of the debate, and here again that the entire theme of this was, अगर आप इस पूरे आर्टिकल को बाद में देख लीजिएगा, if you read it, you will find that a lot of things which this question was talking about was present in this particular editorial which had come in the newspaper. The autonomy of states in their relation with center depends less on any ideological distinction between parties than on nature of power sharing among them. When the government at the center is dependent on regional parties for survival, it is more accommodative towards aspiration of constituent groups, linguistic, religious, ethnic or political. And then it says, फिर उसके बाद ही और कुछ examples दिए हुए हैं, right? There was another article that had come in the newspaper, a new phase of one party dominance. This has also come on 15th of August 2022, and here again the author has talked about a few things of that how the regional parties are being compromised by the central ruling party, etc. तो उसी theme पे UPSC ने एक question पूछ लिया. What are some of the things that could have gone into this particular question? See, national parties, कुछ मैं points लिख के ले आया था. National parties in India favor centralization owing to the following reasons. Why do they favor centralization? First, due to maintain the unity and integrity of the nation, they believe that the regional parties have only a parochial outlook, have only a regional perspective, but we have a national and a broader outlook. Second, apprehension that the regional parties may not realize the goals of social justice. They may not focus on the issues of tribals, on the issues of the Dalits. They may not issue on the focus on the issues of women, minorities, etc., which the national parties only can address, and that is why they try to make more and more centrally sponsored schemes. They try to control more of power in their hands. To speed up economic development, this is also another aspect. Yes?
We can talk about ideologies that union is having,
Like?
one nation, one ration card.
Yes, you can talk about that, है ना? One nation, one ration card, vaccination की पूरी ड्राइव हो गई, उसके अलावा बहुत सारे और थीम्स हैं, सेंट्रली स्पॉन्सर्ड स्कीम्स एक्सेट्रा, कुछ भी आप इसमें मेंशन कर सकते हैं. एनीवे, सो सेंट्रलाइजिंग टेंडेंसीज ऑफ कॉन्स्टिट्यूशन ऑल्सो इंसेंटिवाइज द national parties to focus on centralization. See why? Because national parties know that they don't have such a great footprint in in states, but they have a great footprint nationally. If they can acquire power nationally, then the constitution also favors them, and therefore they favor more of centralization. Like, for example, if you look at BJP or Congress, two big national parties, do they really have any presence in Kerala, Tamil Nadu, West Bengal, Andhra Pradesh, Bihar, right? Odisha? They have been wiped off all of these parties. Even for that matter, अगर आप थोड़ा सा पीछे चले जाएं, 10 साल पीछे चले जाएं, पंजाब, महाराष्ट्र, उत्तर प्रदेश also. You don't need to, ज्यादा पीछे जाने की जरूरत नहीं है पास्ट में. सिर्फ 6 साल पीछे जाएंगे तो उत्तर प्रदेश will be also out of equation, controlled by regional parties. तो बचा क्या फिर? बचा क्या? राजस्थान, मध्य प्रदेश, हरियाणा, दिल्ली. दिल्ली तो स्टेट भी नहीं मानते आधे लोग. कर्नाटका, यही तो स्टेट्स बची बस फिर. और नॉर्थ ईस्ट. और नॉर्थ ईस्ट के अंदर भी अगेन द थीम्स ऑफ politics is very different there. You may have national political parties there, but the theme of politics is very, very different there because it's very diverse region. So Jammu and Kashmir, again, no national party. So you get the point. Central parties, national parties think that anyway we can't acquire power in the states. So why focus on state issues? Let's focus on national issues. But see, you must also bring the other side of the story. ऐसा नहीं है कि national parties केवल centralization promote करती हैं. वही जो बात उसने बोली. Whenever the state parties, whenever their coalition partners are regional parties, they then raise the issues of the states as well. And it also depends upon whether national party is in power or in the opposition. When they are in the opposition, then they must be controlling power in some states. So they tend to talk about federalism. And whenever they come in the power at the center, they talk about centralization. See, you can see this. आपको नाम लेने की जरूरत नहीं है पार्टी का, बट आप ये देख सकते हैं. जब बीजेपी ऑपोजिशन में थी, तो वो फेडरलिज्म की बोगी लेके घूमते थे इधर उधर. बिकॉज दे न्यू दैट वी आर नॉट इन द सेंटर. तो वो बोलते थे कि ये अटैक ऑन फेडरलिज्म है, ये है, वो है, एंड ऑल ऑफ दोस थिंग्स. When they came in the opposition, when they came in power, Congress has now started to talk about federalism. So it is also a matter of convenience for the political parties, national political parties, to talk about whether focus on regionalism or focus on center or focus on centralization. Now, why are regional parties focused on regional issues only and not on centralization? Because regional parties in India do not have a lot of footprint beyond their states. बीजू जनता दल, TRS, DMK, इनका अपनी स्टेट के बाहर कुछ है ही नहीं. So why will they talk about centralization? Because they know that if we can't acquire power in the entire country, why should we talk about centralization? That will be even more detrimental to us. Valid logic or not? Right? So a few points here as well. Why are regional parties in favor of more autonomy? No previous example for regional parties to scale to national level. तो regional party को पता है कि भाई ना तो पहले कोई अभी हुआ है ऐसा और ना शायद आगे फ्यूचर में होगा. So why focus on centralization? See, DMK, for example, if it starts pitching for centralization, my question is, does it have any party in the past which has gone from regional to national? There are hardly any parties which have gone from regional to national. बहुत मुश्किल है, because you need to have a very wide appeal to the voters to be able to be a national party. It's not very easy. Then cause of origin, see, the regional parties have been formed on the very idea of regional autonomy. DMK, TRS, BJD, Shiv Sena, these all regional parties have been formed on the very idea of states should be given more power. अब वो अपने मेन ऑब्जेक्टिव से गोल पोस्ट थोड़ा ना चेंज कर सकते हैं. अब वो बोले नहीं, national issues are more important. They can't. You get the point? Then uniqueness factor. Several regional parties are breakaway units of national parties. TMC. How will I show that I am different from Congress? How will the portions of Congress that split in Tamil Nadu show that we are different from them? To show yourselves as different, you need to have a uniqueness factor also, and that uniqueness is that we talk about state issues, they don't talk about state issues. And then backwardness of the region as well. They say that, you know, the region has remained backward because of the ignorance of the central political parties, national political parties. There should be more devolution to the states so that states have more autonomy, etc. So this was a tough question which was asked in 2022, and you had to think on the spot. So questions like this would also come, but they can be tackled if you think a bit in the examination hall. इसकी तैयारी करना मुश्किल है, मैं ये बिल्कुल बोलता हूँ. वो एक एडिटोरियल पढ़ के आप आंसर लिखाएं, इसका नहीं होगा. देखिए, you need to have general observance power as well. सोचना पड़ेगा आपको. I also had to think about this particular question while framing the answer when UPSC asked this question. Is this clear? Can we move further? Now let's move on to some of the other. So ठीक है, anyway, basics of constitution से related बहुत सारे सवाल पूछती है UPSC. This was a question that was asked in 2021. Please have a look at it once. Constitutional morality is rooted in Constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. No need to beat around the bush. Simply start by explaining what is constitutional morality. Constitutional morality refers to steadfast adherence to the principles and the values of the Indian Constitution irrespective of circumstances. It means going beyond the literal text of the Constitution and looking into the spirit of the Constitution. Constitutional morality का मतलब होता है कि आप Constitution के टेक्स्ट के बियॉन्ड जाकर Constitution मेकर की इंटेंशन को के बेसिस के ऊपर जज करें कि क्या होना चाहिए और क्या नहीं. You go into the basic principles and the values of the Indian Constitution. That is what constitutional morality is. Now it says that आपको constitutional morality explain करना है, और ये वाली statement देखिए, it's rooted in the Constitution itself and is founded on essential facets. तो ये भी explain कीजिएगा. The idea of constitutional morality can be seen in multiple provisions of the Indian Constitution, including the preamble, which talks about the idea of justice, equality, liberty, fraternity, India being a sovereign democratic republic. Fundamental rights that further elaborate upon the idea of secularism, equality, idea of liberty, freedom of an individual. Directive principles of state policy that highlight the importance of social and economic democracy. For example, it talks about equal wages for equal work for men and women. It talks about distribution of resources of the society in such a manner so as to subserve the common interest of the society. It talks about implementation of a uniform civil code to bring all the citizens, irrespective of their religion, under one common law. Right? It talks about the role of the state as a welfare state to provide nutrition, better living conditions to its citizens. So how is constitutional morality within the spirit, within the provisions of the constitution itself? Example de diya. Then it says that you have to explain constitutional morality further with the help of relevant judicial examples. You may give examples of Keshwananda Bharti case. See, what is Keshwananda Bharti case? Court is saying that there is a doctrine of basic structure, that the parliament cannot amend the constitution fully. Parliament does not have unlimited powers to amend the constitution. Where is this coming from? From the idea of constitutionalism, from the idea of limited government, which is nothing but constitutional morality. यही तो फॉलो करके कोर्ट कह रही है कि पार्लियामेंट की पावर्स टू अमेंड द कॉन्स्टिट्यूशन आर नॉट अनलिमिटेड. You may give example of Shabrimala case, where the court is saying that irrespective of whether the constitution talks about that the state can regulate essential religious practice or not, but the most basic idea on which the constitution rests is equality. That should not be violated in any action of the state. That is why they say that even the women between the age of 10 to 50 should be allowed to enter into the Garbhagriha or the sanctum sanctorum of the Shabrimala temple. The Navtej Singh Johar case, where the court is declaring section 377 of the Indian Penal Code as unconstitutional, parts of it of course, as unconstitutional, because every individual according to Article 21 has a right to personal liberty, and this is a matter of personal liberty for an individual what sexual orientation that he chooses to have. Idea of constitutional morality on the basis of which court based its judgment. Minerva Mills case, in which the parliament through 42nd Constitutional Amendment Act is trying to expand its amendment powers in an unlimited manner. The court says that the powers of the parliament to amend the constitution cannot be made unlimited by its own amendment. Again, the idea of limited government present, again an example of constitutional morality. Menaka Gandhi case, right? Whatever, इतने सारे cases हैं जो so many of them, श्रेया सिंगल case, मेनका गांधी के, actually देखिए कोर्ट की कोई भी जो important judgment होती है ना वो constitutional morality पे ही based होती है. समझिए कॉन्स्टिट्यूशन मोरालिटी है क्या? बस वो ये है कि जो कुछ भी हो कॉन्स्टिट्यूशन में क्या लिखा है, लॉ में क्या लिखा है, ये सब तो बात की बात है. पहले ये बताओ कॉन्स्टिट्यूशन का बेसिक प्रिंसिपल क्या है? इक्वालिटी है, सेक्युलरिज्म है, डेमोक्रेसी है, फेडरलिज्म है. ये सब नहीं वायलेट होना चाहिए किसी भी केस में. ये बेसिक स्पिरिट नहीं अफेक्ट होनी चाहिए. लीगल टेक्स्ट क्या कहता है क्या नहीं कहता है, हाउ डज इट मैटर? That is what is constitutional morality. That's why I'm saying steadfast adherence to values and principles of the constitution irrespective of these circumstances. This idea is present in multiple provisions of the constitution itself. And then you give examples of this, and then to round it off, you say that even though the constitution makers have written the constitution, but we must understand the basic spirit of the constitution in order to determine what is correct or right, which is what is correct or wrong. Because ultimately, unless we follow the basic idea of the constitution, rest of the things are going to fall apart. Something like that you may write down, or maybe some quote you can write down, or something like that to end the answer of why basic morals of the constitution are the most important thing. Is that clear to everyone? Can we proceed further? Very simple question, but you must know what is constitutional morality in the first place. और कुछ ज़्यादा कोई rocket science नहीं है फिर से. Then, let's move on to the next question. This is a very important theme on which UPSC keeps asking questions. Judicial conflict with executive, legislature, etc. Judicial overreach. So it says that judicial legislation, that is judiciary making rules, judiciary making laws. We have seen so many times judiciary has laid down rules कि दिल्ली के अंदर इस डेट के बाद के डीजल व्हीकल्स नहीं अप्लाई करेंगे. क्या है? रूल ही तो है. विशाखा केस, दिवाली के ऊपर फायर क्रैकर जो हैं वो 8 से 10 के बीच में फोड़े जाएंगे. रूल ही तो है. दिस इज रूल ओनली. व्हाट एल्स? दिस इज जुडिशियल लेजिस्लेशन ओनली. That when the flow test will happen in Maharashtra, we will observe the flow test. Rule ही तो है. So it says judicial legislation is antithetical to the doctrine of separation of powers as envisaged in Indian Constitution. In this context, justify the filing of large number of PILs, praying for issuing guidelines to the executive authorities. अब देखिए दो टॉपिक्स को उसने मिक्स मार दिया यहां पर. One part of the question is saying, read it very carefully. It is saying judicial legislation is against the idea of doctrine of separation of powers which is mentioned in the Constitution of India. और फिर वो कहता है इस कॉन्टेक्स्ट में, इस रिस्पेक्ट में आप ये जस्टिफाई कीजिए फाइलिंग ऑफ लार्ज नंबर ऑफ पब्लिक इंटरेस्ट लिटिगेशंस PIL फॉर इशूइंग गाइडलाइंस टू द एग्जीक्यूटिव अथॉरिटी. अब देखिए क्वेश्चन बड़ा सिंपल है एक्चुअली. वो ये कह रहा है जो आजकल PIL फाइल की जाती हैं वो पहली बात तो क्यों की जाती हैं? Why do people file PIL and ask the judiciary to issue guidelines? Because of failure of the government, because of the failure of the legislature to make the rules and the laws. So people have now found a new way in the PIL to approach the courts and ask them to do justice, to issue the writ of mandamus or to make certain rules etc which can then act as law. ये पूछ रहा है वो एक. तो एक पार्ट तो आपके आंसर में ये आना है कि भाई लोग क्यों अप्रोच करते हैं कोर्ट PIL फाइल करके. PIL पे क्वेश्चन नहीं है. PIL फाइल करके लोग कोर्ट अप्रोच क्यों करते हैं और इस कॉन्टेक्स्ट में उसके अंदर आपको कॉन्टेक्स्ट क्या लगाना है कि ये जो है गलत है, ये सेपरेशन ऑफ पावर्स के कॉन्सेप्ट के खिलाफ है. और तो basically it is that whether judicial legislation, why it is required and why it is not desirable. This is the theme of the question. ये है एग्जामिनर एक्सपेक्ट कर रहा है. अब आप इसमें कुछ भी उल्टी सीधी दुनिया जहान की बकवास लिख देंगे, PIL और ये और वो क्वेश्चन है ही नहीं है. यू गेट द पॉइंट. दिस आप ध्यान से पढ़िए ना. इन दिस कॉन्टेक्स्ट, इस कॉन्टेक्स्ट में बताइएगा, इस चीज को एग्जामिन कीजिएगा. तो उसने पहले ही कह दिया है कि भाई जुडिशियल लेजिस्लेशन इज अगेंस्ट सेपरेशन ऑफ पावर्स. एक तो ये मतलब आपको बात एनालाइज करनी है अपने आंसर में. एंड सेकंड इट सेज दैट जस्टिफाई फाइलिंग ऑफ PILs asking for intervention by the courts. Is this clear? Now, with this two things in mind, look at the question again and think what would be the introduction or way you would write this answer. Think about it first. सोचिएगा पहले. दो चीजें लिख ली वो जो थी, judicial this thing is separation of powers का violation, and question is justify the filing of large number of PILs by people praying for issue of guidelines to the executive authorities. We can start with separation of powers, but is the question about separation of powers? Yes, ma'am. Again, is the question so much about horizontal distribution of power? ठीक है, पर चलो दोनों, मतलब I am not disagreeing with what you people are saying, horizontal distribution of powers or the separation of powers, etc. You could begin with that, fair enough. फिर आगे कैसे लेके जाएंगे? लिखा तुमने ये, तो लिखोगे नहीं तो सोचोगे कैसे? तुम लोग दिमाग में ही सोच लेते हो क्या? इतने ज्यादा तेज हो? आर यू सो शार्प कि क्वेश्चन देखा नहीं और मतलब एकदम छप गया आंसर दिमाग में? इतनी तो प्रैक्टिस नहीं है तुम लोगों की, मुझे पता है. यस सर. ये सब कहां नहीं लिखोगे? क्वेश्चन की थीम सेपरेशन ऑफ पावर है, सिर्फ वो नहीं है क्वेश्चन की थीम ना. एंड देन फिर उसके बाद कैसे आगे लिखोगे? और फिर क्या करोगे? डोंट यू थिंक कि उल्टा होना ज्यादा बेटर रहेगा? मे बी. ठीक है, ओके, फेयर इनफ. और बताइए. यस सर. Fair enough. So he's saying that I will begin with talking about PIL regime, how that has led to judicial activism. In several cases, the court has laid down guidelines and rules in order to do complete justice in certain cases, but this has been a point of criticism against the judiciary because of the following reasons: 1, 2, 3, 4. And then I say, but at the same time, these actions of the judiciary to issue such guidelines are justified because of the inaction of the legislature and the executive. For example, what happened in Vishakha case, you may write down as an example, right? You may talk about the Vineet Narayan case also. You may talk about the inaction of the executive and the legislature to prevent criminalization of politics. That is why the court had to interfere in Lily Thomas versus Union of India. Once you have mentioned all of this, then you must give your analysis. That Constitution of India is based on the idea of separation of powers. If any one organ on the justification that the citizens are not getting enough justice interferes into the actions of the other, then it would disturb this balance which has been created between the various constitutional bodies. And then you may say that not only would it affect the legitimacy of the executive and the legislature, because people would always run after the judiciary to seek justice, but it would also make judiciary prone to political pressures. If see, the problem with PIL is, and judiciary doing all of this is, that then the people will start looking at judiciary more like government. And when you act like government, you need to also be responsible like government, which means that people will also ask questions of the judiciary, and which means that जो अभी हो रहा है ना, ट्रोलिंग हो रहा है CJI का, वैसा ही होगा. Why? Because जब जुडिशरी हर चीज में इंटरवीन कर रही है, तो फिर अब लोग कैसे दूर रह जाएंगे उससे? Citizens will also want to demand questions of the judiciary in the same manner as they do of the government, because जब आप गवर्नमेंट का काम कर रहे हो तो गवर्नमेंट की तरह जवाब भी दो. This will disturb the entire balance of power. So how do we overcome this? You mentioned that in the conclusion. See, there are multiple ways to answer this question. That separation of powers वाले argument से भी आप चालू कर सकते हैं. You may start from the argument, you simply start from that in several recent cases, judiciary has laid down rules and laws and issued directions to the executive authorities. This creates several problems, and then you justify, or you go the other way. This can be justified on the following grounds, but this has downsides, whichever way. So let's say, for example, let's talk about one approach which could have been taken, that in this question you talk about recent examples of judicial legislation. ऐसे लिखते हैं स्ट्रक्चर. जब मैं कहता हूं आप लोगों की स्ट्रक्चर लिखिए इसका, फिर उसके बाद आंसर लिखिए, सीधा आंसर निकलने पे मत भाग लीजिए. जब आप ऐसा 100, 200, 300 क्वेश्चंस के साथ कर लेंगे तो अपने आप दिमाग के अंदर आना शुरू हो जाएगा. देन यू वोंट नीड टू इवन राइट डाउन ऑन पेपर. पर वहां तक जाना तो पड़ेगा, वो फासला इतनी आसानी से तय नहीं होगा. मैं पहले दिन ही जाके जिम के अंदर 100 किलो की डेडलिफ्ट उठाना शुरू करूं, कमर पकड़ के बैठ जाऊंगा. I have to first build strength. I have to do some basic mobility, and then slowly I have to increase my weight. That is how it happens. पहले दिन ही विराट कोहली ने जाके सीधा छक्का नहीं मार दिया था. You have to do basic things and then you reach there. So, recent examples of judicial legislation, criticisms of judicial legislation. I am taking one approach, but जरूरी नहीं है ऐसे ही लिखा जाए. Criticisms of judicial legislation. It leads to violation of principle of separation of powers. It gives excessive powers to the judiciary. It disturbs the balance that has been created between various organs of the state. It makes the judiciary prone to the political pressures. It leads to the tyranny of the unelected, because judges are disconnected from the masses. किस जज से मिले आप आज तक? आप एमएलए को शायद फिर भी मिल ले, एमपी को फिर भी मिल ले, कौन से जज से मिले हैं आप सुप्रीम कोर्ट के? वो तो निकलते ही नहीं साहब. उनका वर्क, नेचर ऑफ वर्क ही ऐसा है ना. दे आर नॉट अमंग द पीपल. वो थोड़े ना वोट मांगने आ रहे हैं. एमएलए एमपी को आना पड़ता है. सो देयर इज हार्डली एनी पब्लिक इंटरेक्शन. इफ देयर इज हार्डली एनी पब्लिक इंटरेक्शन, हाउ विल दे गेट टू नो द प्रॉब्लम्स ऑफ द पीपल? If you don't know the problems of the people, what kind of rules are you making? They are only being made in ivory towers. AC office में बैठ के रूल नहीं बनते. You have to understand the problems of the people, because rules are not for you. Rules are for people. Anyway, so once you mention about certain criticisms of judicial legislation, then you write down the justifications for the same. And then you mention in passing some dangers of this justification. इसकी dangers क्या है? It will completely do away with the legitimacy of the executive in the legislature. People will lose faith in the executive in the legislature completely, and they will only run to judiciary all the time. इसको दूसरे तरीके से भी लिख सकते हैं, that you first start with this. मतलब this could be, what I mean to say is, this could be second, this could be first, then this could be 3, and this could be 4th. 3 and 4th will be more or less same. And once you mention that, then 5th you would talk about way forward. How do we resolve this? इसको कैसे resolve किया जाए? Way forward, you will talk about that the legislature and the executive need to be more proactive. We need to increase the working time of the legislature and the parliament in India. You may talk about that the judiciary needs to observe judicial restraint. Right? You may also talk about that this is an extraordinary power that has been given to the judiciary, but it must be responsible with the use of its powers. Because ultimately, judiciary, we follow the idea of constitutional supremacy and not that of judicial supremacy in India. All the 3 organs must respect each other's boundaries. Otherwise, it would lead to massive chaos. But जब justification लिखें तो वो भी और ये भी लिखें कि ऐसा नहीं है कि जब भी जुडिशरी ने जुडिशियल लेजिस्लेशन किया उससे गलत ही हुआ है. Judicial legislation was also inevitable at certain times because the executive and the legislature had failed to act upon certain issues, and that resulted in violation of basic fundamental rights of the citizens of India. That is why the judiciary had to intervene, and it used its extraordinary powers under 142 in order to do complete justice in various cases. Right? So you mention about that, and here in this जब criticism लिखेंगे तो उसमें एक बड़ा मेजर थीम जो है किस चीज का रहेगा? वायलेशन ऑफ सेपरेशन ऑफ पावर्स. एंड सो दिस स्पेसिफिकली हैज टू बी देयर. ये ज्यादा सबसे इंपॉर्टेंट चीज है. ये इस पे एक पूरा पैराग्राफ डेडिकेटेड होना चाहिए. 2-3 पॉइंट्स डेडिकेटेड होने चाहिए. व्हाट इज सेपरेशन ऑफ पावर्स? Why is separation of powers important? Maybe give 1 or 2 examples of separation of powers in the Indian Constitution, 121, 122, 212, 211, 212, etc. Article 50 of the Constitution. उसका passing reference दीजिएगा. That should be enough. Recent examples से अगर आप begin करेंगे तो 20-30 word इसमें लग गए. Criticisms of judiciary, 4 point भी of judicial legislation लिखेंगे, example देंगे, 4 point भी लिखे तो 40 से 50 word इसमें लग गए. इसको एक्सप्लेन करेंगे 30 वर्ड इसमें लग गए. सो कितना हो गया? 80, 110. जस्टिफिकेशन भी कम से कम 3-4 पॉइंट लिखेंगे, 50 वर्ड इसमें लग गए, 50 से 60 वर्ड. डेंजर्स एंड क्रिटिसिज्म वगैरह वो तो ऑलमोस्ट सेम है. एक आधा अगर साथ में लिख डाला तो फिर ज्यादा कुछ है ही नहीं. डेंजर्स अगर लिखा तो मे बी अलग से 20 वर्ड और लिख दिए. एंड देन यू टॉक अबाउट वे फॉरवर्ड, मे बी अगेन 40 to 50 वर्ड्स. डन. Yes. Yes, of course. In criticism, you must talk about accountability. वही तो मैं बोल रहा था. Accountability. There is no accountability of judiciary. On what basis are they making rules? Executive and legislature have to stand in front of people every 5 years asking for votes. Policies should not be made by the judges. Policies should be made by those people, those who have administrative experience. ये criticism है. Policies should be made by those people, those who have administrative experience. Policies should be made by those people, those who have interaction with the citizens, those who reach out to people. Those who have limited interaction should not be making policies because those policies will not be people centric. यहां पे आप innovate भी कर सकते हैं. You may talk about that second ARC talks about citizen centric governance. Citizen centric governance can never be ensured by judiciary because the judges do not have such mass contact. The judges do not necessarily have technical understanding of how roads should be built, how ports should be built, how highways should be designed. All these things can only be told by an expert, which is in the administration, in the administrative machinery. You get the idea? Can we proceed further? Yes. What on banning of? Acid. हाँ. ठीक है. वो कुछ भी मैम एग्जाम्पल दीजिए. वो तो मैंने बोला ही ना आपको. कुछ भी दीजिए, चाहे विशाखा केस का दीजिए, एसिड का दीजिए, जिसका भी दीजिए, वॉट एवर इट इज. To do complete justice, to protect the fundamental rights of the citizens. Bhai, a woman has approached you and she's saying that, sir, I have been sexually harassed at my workplace and there is no law which is there in place. Please give me justice. My assaulter was in a powerful position as compared to me. I can't speak out against him. It is double injustice against me. एक तो उसने sexual assault किया, ऊपर से वो मेरा बॉस है. अगर मैंने उसके खिलाफ कुछ बोला तो वो मेरे को निकाल देगा नौकरी से. कोई लॉ नहीं है, कुछ नहीं है, आप मेरे को जस्टिस दीजिए. फंडामेंटल राइट्स, जस्टिस, टू डू कंप्लीट जस्टिस, टू एनफोर्स द फंडामेंटल राइट्स ऑफ द सिटीजंस, टू नॉट सी injustice being done to any citizen in the country, in any part of the country. That is what is justice. in absence of laws or policies or action of the state, whatever we. ठीक है? हाँ. सर जो मर्जी लिखिए, कोर्ट लिखिए, नहीं लिखिए, बात समझ में आ गया ना? भावनाओं को समझो सर, समझ रहे हो? जो मर्जी लिखो, क्या फर्क पड़ता है? आप लोग अभी भी, मैं तीसरा सेशन है ये, मैं अभी भी बोल रहा हूं, आप लोग अभी भी कॉम्प्लेक्सिटीज और नुआंसेस में चले जाते हो. क्या हम ऐसा लिख दें, वैसा लिख दें? बात समझ गए ना? उसके बाद अब जैसा लिखें वो जस्टिफाई होना चाहिए, बस खत्म बात. नुआंसेस में मत जाओ कि हम क्या ऐसा लिख सकते हैं, ऐसा लिख सकते हैं. हाँ भाई बिल्कुल ठीक कह रहे हो आप, वॉट एवर यू आर सेइंग इज राइट. डोंट सीक वैलिडेशन फ्रॉम मी. You are a smart individual to understand that what I am saying, does that relate to what you are saying? If that does, just समझिएगा सर, just, rest doesn't matter. डिटेल देखिए, उन्होंने एसिड अटैक लिखा, मैंने कुछ और लिख दिया, क्या उसका आंसर ज्यादा अच्छा हो गया, मेरा खराब हो गया? You get the point? It doesn't matter. कुछ भी लिखो सर, ठीक है? We'll have a look at one more question and then we'll go into a break for a few minutes. So this one was, I think, very simple question. Discuss the desirability of greater representation to women in higher judiciary to ensure diversity, equity and inclusiveness. So first you have to begin with the problem. What is the problem? Lack of representation of women in judiciary. Less than 2% representation. Supreme Court, High Courts, there are hardly any women. What kind of problems does it create? It leads to an insensitive judiciary. It leads to a judiciary that does not represent the 50% of the Indian population. It leads to a judiciary that comes with only a certain mindset and a background, but doesn't necessarily understand the problems of the women. It leads to judgments as well, which are also male-centric. And it does not give enough confidence to women to approach the courts in the country, because they know that the person who will be sitting there would be a man. If a man has done injustice against me, how can I expect justice from a man? That is the mindset, right? I'm not saying that this is correct, but I'm saying that this is the mindset. You are a rape victim. Would you not be more comfortable telling your plight to a woman judge? How could you be comfortable telling this to a man who's sitting in front of you as a judge? You would always doubt. You would always have an apprehension. You would always be reluctant. So mention the problem, and that itself answers the question of diversity, equity and inclusiveness. Why is it important to have a diverse judiciary, to bring in diverse viewpoints, to make the judgments more comprehensive, not only from one perspective but from multiple perspectives? It is important to have equity as well. Women have been underrepresented in judiciary in the past, in the legal profession in the past. They have not approached the courts because of various reasons. The enforcement of the fundamental rights of the women remains a major challenge. That's why there should be a greater representation. Give reference of 15.3, say for example. And then it says inclusiveness as well. It should be inclusive also. Very simple question. I don't think there was anything rocket science about it. In fact, there was a statement which had been made by the Chief Justice of India when he was retiring, that I wish that there were more of women in the judiciary. So once you write all that, then you must mention कि क्या किया जा सकता है इसको करने के लिए. What can be done? What can be done? इसमें एक चीज और mention कर सकते हैं आप, that why is the representation of women in judiciary so low? Your introduction could begin by talking about, say for example, that the representation of women in Indian judiciary is low. इसके लिए एक दो पॉइंट जस्टिफाई कर दीजिए. एक बड़ी अच्छी इंट्रोडक्शन जो मेरे को लगता है कि इस क्वेश्चन पे हो सकती थी, क्योंकि जब ये सवाल पूछा गया उससे कुछ महीने पहले ही पाकिस्तान में द चीफ जस्टिस वाज अ वुमन. So you could have said that recently Pakistan has seen a woman chief justice. This raises certain questions with respect to representation of women in Indian judiciary, which is at an all-time low. Some of the reasons for this could be, you may mention about some reasons for the underrepresentation of women in judiciary. You could talk about patriarchal attitude of the society. You may talk about that how within not many women are encouraged to take up legal profession because it is considered to be a man's profession. You may talk about that women often have to deal with dual responsibility of taking care of home as well as their profession, as a result of which in a highly competitive, ultra competitive profession like litigation, their career suffers because they have a dual responsibility to play. And then you may talk about that even if you look at the collegium, when it consists of men, they tend to prefer men only, not the women. So something like that you mention. Then you talk about that why is it desirable. Why desirable में दो तरीके से लिख सकते हैं कि अगर होगा तो उससे ये होगा, या नहीं है तो उससे क्या प्रॉब्लम है. विच एवर वे, दोनों सेम चीजें नहीं लिख सकते बार बार. यू गेट व्हाट आई एम ट्राइंग टू से. इफ more women will be there, what will happen? Either right from a positive side, or because less women are there, what happens? Right from that perspective, whichever way. So justifications basically why it is desirable, and then you just mention a few things for way ahead. Done. Is that clear to everyone? Right? So we'll go into a break for 5 minutes. We'll come back in 5 minutes and discuss some of the other questions as well. Of course, see, I may not be able to cover all the questions, but again, my whole attempt in all these 3 sessions has been to reorient your looking at the questions. Because somehow you people have built some conception in your mind about answer writing, which is not something what the examiner expects. He expects to see how you think. And that can only happen when you actually literally think about the question and not just about what answer I have to write. Question पढ़ेंगे तो आंसर खुद ब खुद आएगा. आंसर की सोचते रहेंगे तो ना आंसर लिख पाएंगे और ना क्वेश्चन को पूरी तरीके से आंसर कर पाएंगे. Right? I'll see you in a few minutes. From the basic themes, UPSC has asked another question which was asked last year. This is more or less a repeat of the question that was asked in 2015. So whoever says UPSC doesn't repeat questions should look at this one. So this one says, discuss the essential conditions for the exercise of legislative powers by the governor. What are the essential conditions for the exercise of legislative powers by the governor? Which essentially means ordinance making powers. Discuss the legality of repromulgation of ordinances by the governor without placing them before the legislature. This is slightly static question. Isme kuch, there is not much of dynamism which is there. Very, very static question. UPSC has stopped asking very static questions. Let me also tell you that. They usually tend to find those themes where they can somehow relate. मतलब centralizing tendencies of federation पूछ रहा है तो भी उसमें वो farm laws और ये सब डाल दे रहा है. So that itself shows that it is not very inclined to ask static questions so that they appear so easy. मतलब पहले से आदमी prepare करके चला जाए. वो चाहते हैं कि prepare करके आओ पर question यहीं पे पढ़ो. ना question अपने घर से आंसर मत prepare करके आना. That is what it is saying. So this one is saying discuss the essential conditions for, इसको जल्दी से discuss कर लेते हैं. Essential conditions for the exercise of the legislative powers by the governor. See, you may begin by giving some recent example of the ordinances etc. made by the governor or even for that matter by the president. To just for example, recently in the state of Maharashtra an ordinance was made over which there was a controversy. These ordinance making powers of the president, of the governor, flow from Article 213 of the Constitution. This is an extraordinary power given to the executive to make a law on the same matter on which the state legislature is competent to make a law. Some certain conditions that should be fulfilled while exercising this power are as follows. Right? So you may start from some maybe recent ordinance etc. as an example. Another could be, another introduction could be general viewpoint or caution of Constituent Assembly towards ordinances. So you may also say that the ordinance making powers of the executive were a matter of intense debate in the Constituent Assembly of India due to its nature of misuse. Since the law in such a case is not made by the representative of the people through a deliberation and discussion mode, rather made in a unilateral manner by the executive alone without any consultation. Therefore, there need to be certain conditions that should be fulfilled in order to make an ordinance. Or you talk about some recent ordinance and then you talk about that in this context it is important to understand that there is always a misuse of, there is a possibility of misuse of the powers of ordinance by the governor of a state, and therefore it must be exercised according to the provisions of the constitution and some of these conditions must be satisfied. तो वो conditions लिख दीजिएगा. What are the conditions for the exercise of the ordinance making powers of the governor under Article 213 of the Constitution? Yes? I can't figure it out like this. One person please at a time. Sorry? When, okay, when both the houses are not in session. So you may write either or whichever. When both the houses are not in session, then he can make, or when if there is a dual legislature, when both the houses are not there, or when either is not there, whichever way you may want to write it. बात तो एक ही है. So when both the houses of state legislature are not in session, what else? और क्या है essential condition? Yes, must be only passed on subjects under state list or concurrent list. Yes, what else? What else? ये तो नहीं है ऐसा public interest, but there must be some immediate requirement of a law. और क्या है? Satisfaction? How will satisfaction of the governor be formed, sir? On the aid and the advice of Council of Ministers. Yes, what else? Not? So, why are you only saying that? Must conform to the limits of the constitution. क्या सब कुछ इसके अंदर कवर नहीं हो जाता? फिर आप बोलोगे कि सर इट मस्ट नॉट बी अगेंस्ट फंडामेंटल राइट्स, फिर आप बोलोगे इट मस्ट नॉट बी अगेंस्ट प्रोविजंस ऑफ कॉन्स्टिट्यूशन, फिर आप बोलोगे इट मस्ट नॉट बी अगेंस्ट लॉज मेड बाय द सेंट. तो एक ही बारी में सब लिख डालो. It must conform to the limits of the constitution. Essential conditions. Then one more, most important, must be placed for approval. अब इसको ना आप ना अलग से भी लिख सकते हो, मैं बताता हूं उसका रीजन क्या है. ये लिंक स्टेटमेंट हो सकता है दूसरे पार्ट के साथ. इसको अगर यहीं पे लिख डाला तो ठीक है, नहीं तो आप इसको लिंक स्टेटमेंट भी एडिशनली और मोस्ट इंपॉर्टेंटली अलग से लिख डाला, अलग पैराग्राफ के स्टार्टिंग. मोस्ट इंपॉर्टेंटली मस्ट बी प्लेस्ड फॉर, क्या हो गया, मस्ट बी प्लेस्ड फॉर अप्रूवल इन फ्रंट ऑफ द लेजिस्लेचर विद इन 6 weeks from the date of the assembly of the legislature. Right? Essential conditions हो गए. Then it says, if we come back to the question again now, it says, discuss the legality of re-promulgation of ordinances by the governor without placing them before the legislature. Now, let's go back. So, the constitution, what does that say about whether re-promulgation is possible or not? क्या कहता है वो? So the constitution is silent about re-promulgation of an ordinance, which means it is possible, it may not be possible. In this context, we need to refer judgments of the court. When you mention in DC Badava case, for example, a matter came up in front of the Supreme Court where the Bihar governor had promulgated more than 256 ordinances over a period of 14 years from 67 to 81, out of which 69 ordinances were re-promulgated multiple times and kept alive for a period of more than 1 decade. The court, while justifying the exercise of re-promulgation on certain grounds, which include a shortened session of the legislature and overburdened nature of the work in the legislature, stated that repromulgation done in any other circumstance would be treated as a violation of the constitution and would be considered as a fraud on the constitution and an attempt made by the executive to seize the powers of the legislature. Therefore, powers of repromulgation, repromulgation of an ordinance must be done only in exceptional circumstances by the executive, because any such exercise would be a direct violation of principle of separation of powers in the Indian Constitution. It is also against the idea of democracy, as in ordinance there is no public discussion on the bill, no public discussion on the provisions of the law, which is very much against the idea of democracy. There are a number of dangers fraught with this. In recent times as well, there have been certain instances of repromulgation of ordinances. Ideally, the executive should refrain from this. ऐसा कुछ करके आप इसको conclude कर सकते हैं. Yes, get the idea. See, you may have read this Bible of polity. In that, the author says repromulgation of ordinance is unconstitutional. I am sorry to say that is not what the court says. The court says that repromulgation of ordinance is only a violation of the constitution, is only a fraud on the constitution when it is not done due to these particular circumstances which I just mentioned. When there is a shortened session of legislature, or when the work of the legislature was too much for it not to be able to consider the ordinance. In other circumstances only, it would be considered as a violation of the constitution or a fraud on the constitution or a violation of principle of separation of powers. Conclusion में आप ये भी लिख सकते हैं that the parliamentary convention evolved in India where the ordinance must be accompanied along with the statement of objects and reasons in the legislature while placing it for parliamentary approval or legislative approval is a welcome practice and must be followed diligently. इस तरीके से भी कुछ लिख सकते हैं आप conclusion के अंदर. Is that clear to everyone? Can we proceed further? Right? Now, तो देखिए क्वेश्चन आया था 2015 में, बिल्कुल एकदम हूबहू सेम क्वेश्चन ही था largely. Resorting to ordinances has always raised concerns on violation of spirit of separation of powers doctrine. While noting the rationale justifying the power to promulgate ordinances, analyze whether the decisions of the Supreme Court on the issue have further facilitated resorting to this power. Should the power to promulgate ordinances be repealed? Let's move on to the next question. This question was kind of an outlier, but not exactly, because there were a number of newspaper articles that have been coming on this. I think I've seen this particular theme also in last few years in the exam, where UPSC is taking up one particular issue from the syllabus, important issue, women issues or environmental issues, possibly next year, this year it could be the minorities or scheduled caste or scheduled tribes or something like that, and then relating it to one of the basics idea of the constitution. So this one is that the most significant achievement of modern law in India is constitutionalization of environmental problems by Supreme Court. See, constitutionalization of something means including that in the constitution or addressing that in the constitution, even though it is not originally a part of the constitution. So Supreme Court of course can't write the constitution, but how can it make environmental problems a part of the constitution through its judgments? It says that discuss this statement with the help of relevant case laws. So you have to discuss a few important cases of the Supreme Court related to environmental issues, and this you should cover not only in your polity section but in your environment preparation as well. Environment के अंदर आपको केवल और केवल ये नहीं पता होना चाहिए कि इस पॉल्यूटेंट से ये प्रॉब्लम होती है और उससे क्या प्रॉब्लम होती है, बट एनवायरनमेंट को थोड़ा लार्जर कॉन्टेक्स्ट में देखेंगे So then you must also know what are the various legislations that exist in India for environmental issues, and what have been the important judgments of the court in order to develop the jurisprudence with respect to environmental issues in India. By the way, there were at least 5 or 6 articles in the newspapers which from time to time had indeed touched upon this particular theme. This was an article which was there in March 29, 2022, where the Supreme Court had talked about a few things related to environment. He said that environment, where for example Chief Justice had said that environment must prevail over other rights. On March 25th, Justice Indira Banerjee observed in the judgment that industrial units which provide livelihood to several thousands of workers and contribute to the nation's economy should not be shut down for not getting prior environmental clearance. So she was talking about right of livelihood. But then what does the Supreme Court say? Finally, that has expressed in course of 4 days divergent views on whether preservation of environment should take a backseat when other rights are at stake. So Supreme Court finally said that environment should be given higher priority over livelihood. Anyway, then we need to balance this. The Supreme Court through PIL, please, has been at the core of evolution of environmental law in the country. ये सब कुछ हिंदू newspaper से है. Its judgments have interlinked survival of humanity to survival of environment by holding that right to life includes right to wholesome environment. It has nudged awareness in public, legislature and executive by underscoring that clean air and water were indeed attributes of dignified life. यही आपको सिंपल तरीके से आंसर में लिखना है. ये आप सबको पता है ये बात. That Supreme Court through its judgments has said that life under Article 21 does not mean mere animal existence, but means life with dignity, which includes right to have a clean environment as well. An individual should have right to clean air, water. Otherwise, an individual's life would be worse than that of an animal. Right? Then you may also talk about that in several cases, Supreme Court has gone ahead and paid compensation as well to the victims of activities by industrial houses, by industries and by the government, which have led to destruction of environment. Polluter pays principle. Right? Then you may talk about so many things are there, right? That, for example, the court has adopted principles of international law into its verdicts. These include principles like intergenerational equity, by which the state is under an obligation to conserve the environment for future generations. The court has expressed its concerns through its various judgments, not only on protecting the rights of the existing individuals, but also to ensure sustainable development so that the future generations could also continue to enjoy the benefits of environment as the past has. Then, against the polluter pays principle, by which the polluter has to pay not only the victims of pollution but is also liable to repair the damage to the environment. The court had brought in the public trust doctrine to hold that state was only a trustee holding the wealth safe for its ultimate beneficiary, the public. So if there is a river or over which the state has the regulation, then someone else should not be just damaging the river, or the state action should not be damaging the river, because the state does not own the river. It is owned by the public. So it is responsibility of the state that whatever actions it also takes does not violate the basic principles of environment sustainability. The principle of sustainable development remains a vital check on unbridled expansion. बहुत सारे multiple articles आए थे. Greens welcome Supreme Court order on eco-sensitive zones around forest area. The Supreme Court has also given a judgment on declaring certain areas around the forest areas as eco-sensitive zones in which only limited kind of human activity would be allowed. Specific cases आपको देखिए पता है तो बहुत अच्छी बात है. आपने एमसी मेहता वर्सेस यूनियन ऑफ इंडिया, सुभाष कुमार वर्सेस स्टेट ऑफ बिहार, इस तरह के 2-3 केसेस लिख दिए तो भी चलेगा. सारा कुछ एकदम वेल्लोर सिटीजन्स फोरम वर्सेस यूनियन ऑफ इंडिया लिख दिया, बहुत अच्छी बात है. लिख डाले तो लिख डाले, बट नहीं भी पता है 1-2 केसेस भी लिख दिए, दैट शुड बी एनफ. Examiner is not expecting you to write case laws. ये law का पेपर नहीं है. Examiner is wanting to see whether you understand that how the judgments of the Supreme Court with respect to the idea of intergenerational equity or polluter pays principle or sustainable development, etc. has ringed a bell in your mind or not. Balance between defense, environmental concerns, a better goal, says Supreme Court. So एक और फिर देखिए इतने सारे ये सब आया. Supreme Court asked center why environment regulator has not been set up. Supreme Court is loud and clear on the noise pollution. HC seeks center stand on plea for implementation of India's promises on climate change. अब देखिए यही चीज है कि जब आप न्यूज़पेपर्स पढ़ें तो इसको आपको रिलेट करना ही पड़ेगा कि ये मेरे किस टॉपिक से रिलेट होता है सिलेबस के. अंधाधुंध न्यूज़पेपर पढ़ने से कुछ नहीं होने वाला. लॉट ऑफ पीपल कम टू मी, सर हमने तो न्यूज़पेपर पढ़े थे पर हमसे क्वेश्चन नहीं हुए. आपने न्यूज़पेपर्स पढ़े होंगे पर ये कोई चाय की दुकान पे बैठ के पढ़ने वाली चीज नहीं है. न्यूज़ आप राजेंद्र नगर में शंकर रोड पे जाइएगा, वहां पे एक चाय का स्टॉल है. वहां पे आपको सुबह 7 बजे बहुत सारे राजेंद्र नगर के अंकल मिल जाएंगे न्यूज़पेपर्स के साथ. वो भी न्यूज़पेपर पढ़ते हैं, आप भी न्यूज़पेपर पढ़ते हैं. उनमें क्या फर्क है और आप में क्या फर्क है? वो आपसे ज्यादा समय लगाते हैं न्यूज़पेपर में, आपको पता है ये बात? देख लीजिएगा कभी जाके. मैं तो बहुत बार बैठा हूं उनके साथ जाके ऐसे ही गप्पे मारने के लिए. सुबह सुबह बोर हो गए, चलो जब प्रिपरेशन कर रहे थे बोर हो जाते थे, सुबह चले जाते थे. वहां पे कुछ ना कुछ उनकी बहस चल रही होती थी, बीजेपी, आम आदमी पार्टी, कांग्रेस, ये वो जो भी कुछ भी, बैठ जाओ उसमें और उसमें थोड़ा सा उनको चिंगारी लगा दो तो बस मजा आ जाता था. बट आप में और उनमें फर्क क्या है? न्यूज़पेपर पढ़ लिया हमने. न्यूज़पेपर, दैट इज व्हाई आई कीप टेलिंग, सबसे पहली चीज प्रीवियस ईयर क्वेश्चंस और सिलेबस. और रोज जब न्यूज़पेपर पढ़ो सिलेबस साथ में होना चाहिए. एंड सी इफ दिस रिलेट्स टू समथिंग इन माय सिलेबस. क्या ये कुछ आप लिखेंगे भी नहीं ना, पॉइंट्स नहीं भी लिखेंगे कहीं पे, नोट्स नहीं भी बनाएंगे, तो भी एक ना 2-3 चीजें चमक जाएंगी एग्जाम में कि अरे वो पढ़ा था, एक चीज वो पढ़ा था, समथिंग लाइक दैट. वो बस ब्रॉड लिख देता हूं आइडिया कि कोर्ट ने बोला था कि इंटरनेशनल कन्वेंशंस आल्सो शुड बी फॉलोड. क्लाइमेट चेंज के ऊपर भी कोर्ट की जजमेंट आई थी. कोर्ट इज आल्सो कंसर्न्ड अबाउट द आइडिया ऑफ दैट द वन हु इज पोल्यूटिंग द एनवायरनमेंट मस्ट नॉट ओनली पे द डैमेज to the victims but must also compensate for the damage that he has caused to the environment as well. So it will be easy that sense. Anyway, so there are a lot of questions, a lot of cases also. I mean, you may write down those cases as well, but see, I'll be very honest, it's not possible to retain all of this. It's not possible. And the other thing is, ये पॉलिटी में तो मैं नहीं पढ़ाऊंगा किसी को. I will not teach this in polity to someone. आप environment में पढ़ लें तो पढ़ लें. If you read this in environment, that is another thing. That okay, there is something called as polluter space principle. There is something called as intergeneration equality, right? You may come across. तो कुछ cases हैं, right? So MC मेहता versus कमलनाथ. 1-2 cases हम discuss करते भी हैं Article 21 में. When we discuss that, you know, Subhash Kumar versus State of Bihar और MC मेहता versus Union of India. But कितना लिख डालेंगे आप इसको? You have to rely upon your broad general knowledge to write answers to such questions. इसकी तैयारी बैठ के ये नहीं हो सकती कि चलो अब एनवायरमेंट रिलेटेड केसेस लिख लेता हूं, अब फिर विमेन रिलेटेड केस, या फिर ये कर भी सकते हो दैट विमेन रिलेटेड केसेस 5 लिख लो अपने नोट्स में, एनवायरमेंट रिलेटेड 5 लिख लो, शेड्यूल कास्ट शेड्यूल ट्राइब्स रिलेटेड 5 लिख लो, तो वो भी अप्रोच कर सकते हो. बट दैट आई थिंक इज नॉट वेरी फीजिबल. आई पर्सनली फील दैट. But you may approach that way also, which is completely your choice. Anyway, next question. This was a very easy question. Right on movement and residence throughout the territory of India are freely available to the Indian citizens, but these rights are not absolute. In this question, you must simply begin by talking about Article 19(1)(d) and 19(1)(e) of the Indian Constitution provide the right to freedom of movement in India to all the citizens. एक तो ये है, या फिर क्या करें, recently the lockdown imposed by the government on the movement of the people during COVID-19 was an example of how Article 19(1)(d) and 19(1)(e) of the Indian Constitution, right to movement and right to residence, are not absolute rights in the Indian Constitution. These rights have been guaranteed by Article 19(1)(d) and 19(1)(e) of the Indian Constitution. The importance of these rights lies in the fact that they allow the operation of India as one common economic entity. They help in promoting the unity and integrity of the nation. They help in promoting the diversity of the nation by encouraging cultural interaction between people of different communities and different regions. But this right is not absolute in nature and can be restricted on the grounds of protection of interest of scheduled tribes and in the interest of general public. For example, the Epidemic Diseases Act and the NDMA Act of 2005 are providing the powers to the state to limit the restrictions, to restrict the movement of the people, which was done and observed during COVID-19. Similarly, in certain parts of India, a regime called as the inner line permit has been imposed by the state, which restricts the entry of outsiders into some of these protected areas. This has been done in order to protect the unique culture and the traditions of the tribals in the country. A very unfortunate incident had happened in the Sentinelese Island, where a foreigner was trying to enter into the Sentinelese Island, which is a protected zone, and was killed by the Sentinelese people. This is a clear indication, but you must also mention that this was an illegal act that was being performed by that individual. The reason for that is again 19 months. तो वो आपने कुछ लिख दिया, एक दो एग्जांपल्स दे दिया and be done with it. That's it. 150 वर्ड का आंसर है टोटल. Is that clear to everyone? सिंपल क्वेश्चन है बहुत. ये मल्टीपल तरीके से अप्रोच कर सकते हैं इसको. Again, try to think that how I can make my answer more unique and different from the rest of the crowd. See, I'm not saying that you do that in all the 20 questions. If you think that okay, I am not in the mood, or I am ठीक है, अभी ये दिख रहा है ना साफ साफ 19(1)D, 19(1)E, right to movement, right to residence, लिखो जल्दी से खत्म करो इसको. ठीक है, that is also fine. But you can again write some example to begin your answer and then relate it and then go in a flow. Clear to everyone? Can I proceed further? लोकल गवर्नमेंट पे क्वेश्चन आया 2022 में. Almost every year there is a question on local government. You can see. There was a question in 2020, there was a question in 2022. Let's see. To what extent, in your opinion, has decentralization of power in India changed the governance landscape at the grassroots? Has changed the governance landscape at the grassroots. So it says that to what extent it has happened, which means that you have to talk about that yes, there has been a change in the governance landscape at the grassroots, but nothing much has still changed. Both things have to be written in your answer. And then some way forward. So how do you begin the answer to this question? Yes? 73rd Constitutional Amendment Act. Okay, you standard way of writing the answer, but tell me, would not everyone be doing that? Certain achievements of local governments, like what? Okay, so you may talk about that how there has been a massive improvement in certain areas due to the, देखिए अब वही है, आपने 73rd से start किया, she is saying that I will write certain achievements और फिर मैं उसको 73rd से relate कर दूंगी. Isn't that a better approach? Yes. Participation of women you could talk about from begin with. Recently the some village or whatever, ऐसे आया भी था ना news कि some village has elected the सरपंच, women सरपंच who was voted as the best सरपंच. अब देखिए ये सब चीजें ना थोड़ी बहुत केस स्टडीज भी प्रिपेयर करनी जरूरी है. मैं हमेशा बोलता हूँ कैंडिडेट्स को कि कुछ एग्जाम्पल्स प्रिपेयर करके जाइए. ये अपना जो एक मिनट आ रहा हूं, अपना जो ये मसाला है पहले से प्रिपेयर करके जाइए थोड़ा सा. वहां पे एकदम जाके इनोवेट करने की कोशिश करेंगे, नहीं हो पाएगा. You may say for example talk about that Chavi Rajawat, an MBA, was elected as the Sarpanch of a village in Rajasthan. This is the prime example of how the grassroots governance in India has changed after the 73rd and the 74th Constitutional Amendment Act. Some of the other impacts, some of the other positive impact of decentralization of power on grassroots governance are as follows: 1, 2, 3, 4. But there are certain problems as well. Therefore, it would be wrong to say that there has been a complete transformation. For example, 1, 2, 3, 4. And then certain changes are therefore required in this. 1, 2, 3, 4, done. You get the idea? Yes?
In introduction, we can talk about Mahatma Gandhi, launch of his idea of local government.
you may begin with Mahatma Gandhi also. You may talk about the idea of Gram Swaraj of Mahatma Gandhi. Yes, what else? Anything else? How? I can get what you're trying to say, but think more over it. So again, undercooked idea, but yes, I can get the point, but you're not able to express it right now. So think about it, how you do that. Right, so yes. Very good. Recently, the Prime Minister had hailed the work done by the PRIs during the COVID-19 and the fight against the pandemic. In this context, we may analyze the following improvements in the grassroots governance landscape made by decentralization done under 73rd and 74th Constitutional Amendment Act. This question is not about 73rd and 74th, please remember that. This question is about how the grassroots governance landscape has changed after 73rd and 74th. You get the point? That's a very good example. Prime Minister made a statement. Prime Minister actually applauded the role of the PRIs. Could be a brilliant statement to start with. Get the point? Right? Anyway, next. The strength, sustenance of local institutions in India has shifted from their formative phase of functionaries and funds to the contemporary stage of functionality. Highlight the critical challenges faced by local institutions in terms of their functionality in recent times. Now, tell me something, what do you mean by functionality? क्या होना चाहिए इस क्वेश्चन में? ये थोड़ा सा कंफ्यूजिंग क्वेश्चन है. क्या होना चाहिए फंक्शनैलिटी में जब बात करें तो? How? But how? But then it comes down to functions and functionaries only. But then it comes to functions. So yes, now this is a confusion for me as well in this question कि UPSC चाह क्या रहा है? क्योंकि funds, functions और functionaries से ही तो functionality बनती है. You get what I'm trying to say? This question, and correct me if I am wrong, if you have a better interpretation of this question. Strength and sustenance of local institutions in India has shifted from their formative phase of functions, functionaries and functions to the contemporary stage of functionality. Now, what I can possibly think, and this is confusing because see, functionality क्या होती है कि क्या कोई चीज काम कर रही है कि नहीं. अब वो किस पे डिपेंड करता है? फंड, फंक्शन, फंक्शनरीज पे ही. And then it says, highlight the critical challenges faced by local institutions in terms of their functionality in recent times. Now, my guess is that in this question, UPSC is possibly pointing towards the increased role of bureaucracy, is possibly pointing towards the use of the agencies for taking up the various functions at the local level, and creation of a number of parallel bodies which has sidelined the role of the Panchayati Raj institutions in India. And especially if you see, it says the local institutions. So you don't need to restrict yourself to PRIs alone. You may talk about the urban local bodies as well. They have become dysfunctional. हम कहते हैं ना ये कि भाई अर्बन लोकल बॉडी डिसफंक्शनल है. तो मुझे लगता है कि इसमें वो चाह रहा है कि आप फंड्स, फंक्शंस, फंक्शनरीज के बियॉन्ड कुछ और चीजों की भी बात करो शायद. बात समझ रहे हो? तो अब बियॉन्ड क्या चीजें हैं? पैरेलल बॉडीज. बियॉन्ड क्या चीजें हैं? सिटीजन एपैथी. Citizens do not participate in municipal and local body elections. They don't care. They don't give a damn. Chutti hai, niklo. That is the attitude of citizens. You may talk about that. The patriarchal character of the local bodies continues to remain. So that is there. You may talk about how the bureaucracy has been given a lot of powers, which has sidelined the nature of the Panchayati Raj institutions. मेरा guess यही है देखिए इस question में, because otherwise when I looked at this question मैंने बोला यार क्या क्या रहा है functionality. मैंने 2 बार तो जाके पहले डिक्शनरी में मतलब चेक किया functionality का कि कहना क्या चाह रहा है. But my guess is that when see देखिए, क्योंकि अगर उसने फंड फंक्शन फंक्शनरीज ही पूछना होता तो वो तो पूछ ही लिया ना. और देखिए हम यूजुअली क्या कहते हैं, प्रॉब्लम्स ऑफ पीआरआईज एंड लोकल बॉडीज आर ऑफ फंड फंक्शन फंक्शनरीज. उसने बोला कि नहीं बेटा, there are other problems also, discuss about those. Here I think you may talk about not just shortage of functionaries but training of functionaries. You may talk about the parallel bodies such as the Delhi Jal Board etc. being created, which have sidelined the functioning of the municipal bodies. Right? You may talk about political interference. You may talk about that how the elections are not conducted on time for a lot of PRIs and ULBs. That has also affected their functionality. So you will have to highlight basically some other additional issues other than funds, functionaries and functionaries in this question. Then the question becomes relatively more coherent and something which we can address. So you would say that in the first phase of the formation of the Panchayati Raj institutions in India, they suffered from the issue of funds, shortage of funds, not having enough funds, being dependent on the state and the center for funds. Second, the shortage of or the not lack of devolution of functions by the state governments, reluctant to share powers with them. Third, the reluctance of the functionaries not being available in enough numbers, not having a dedicated cadre of officers, etc. Once you have mentioned that, you will say that some of these problems have been addressed in the past. For example, the 13th Finance Commission had recommended devolution of some funds to the Panchayati Raj institutions and the urban local bodies. We have initiated programs such as JNNURM in order to provide funds to the urban local bodies. We have set up training institutions. We have made it mandatory in some of the states for the Panchayati Raj functionaries to undergo a training. ये mandatory हो गया बहुत सारी states में. They have to undergo a 6 months training. You may talk about that functions maybe we have seen the states becoming more willing to devolve functions to them, but there are a number of other problems which affect their functionality in the present times. Then you mention about 3-4 of those problems and then suggest how you overcome those problems. मेरे को तो यही इस क्वेश्चन का समझ में आया है कहानी. अदरवाइज वो फंक्शनैलिटी और फंक्शनरीज को फंक्शनरीज को कैसे अलग कर रहा है ये बड़ा बताना मुश्किल है, बिकॉज फंक्शनैलिटी इज अल्टीमेटली डिपेंडेंट ऑन दोस 3 थिंग्स ओनली. नो एथिक्स की मतलब I don't think transparency and all, but maybe you could talk about leadership, lack of leadership in the local areas. You may, as I said, talk about citizen apathy, excessive bureaucratic interference. देखिए 5 पॉइंट तो ये हैं वैसे. ये हम जब डिस्कस करते हैं पंचायती राज इंस्टीट्यूशंस, ये 4-5 पॉइंट में डिस्कस करता हूं अपनी क्लासेस में. पैरेलल बॉडीज को सेटअप करना, आई डिस्कस अबाउट एक्सेसिव इंटरफियरेंस of the bureaucracy. I talk about the setting up of the parallel institutions in the local bodies which are taken away the functions of the local bodies. We do talk about lack of the leadership. We do talk about lack of participation of women. We do talk about elite capture of these institutions. I think 6-7 पॉइंट वो भी बहुत हैं वैसे तो, वो भी फंक्शनैलिटी अफेक्ट कर ही रहे हैं. मेरा गेस ये है कि यूपीएससी जानबूझ के कैंडिडेट को ले जाना चाहता है कि तू बता मुझे फंड फंक्शन, बिकॉज क्या होता है सब जगह fund function functionaries is the problem which is cited, but there are other problems also with respect to functioning of the local bodies. So that is what the guess is that I have. Yes, IR committee. Okay, I mean, so what he said that, I mean, I didn't know about this, that the Manishankar Ayer committee on the Panchayati Raj reforms had suggested that even though they have been devolved funds and some functions by the panchayat, by the state governments, but the functioning of the government is such that it is interlinked, that the functioning of the delivery of the services is not just dependent on the panchayats as such. But अगर सपोज कर पानी आना है, पानी प्रोवाइड करना है, तो अल्टीमेटली स्टेट को कितना पानी मिल रहा है वो भी तो डिपेंडेंट है उसके बेसिस पे कि पंचायत कितना पानी देगी अपने लोगों को, समथिंग लाइक दैट. पॉलिटिकल विल इज लैकिंग, बट वो भी अगेन फंक्शंस में आ जाता है आई गेस. सी बट अगर वो इतना डीप पूछ रहा है ना जाके, तो कुछ नहीं हो सकता. बट आई थिंक इफ यू मेंशन सम ऑफ द अदर इश्यूज अपार्ट फ्रॉम फंड फंक्शन फंक्शनरीज, आई थिंक दैट शुड वर्क इन दिस क्वेश्चन. यस सर. Yes, absolutely. Technical expert, वही मैंने बोला ना, technical expertise is required and they do not have enough training properly given to them, despite having functionaries, not enough training being given to them. So उस तरह की चीजें आप लिख सकते हो possibly, right? वो भी अच्छी बात है. सोशल ऑडिट मैकेनिज्म, मिसयूज ऑफ फंड्स, करप्शन इन लोकल गवर्नमेंट्स, ये भी तो एक इशू है. ये भी अच्छा. एक चीज मेरे को इससे ध्यान आई, और एमसीडी दिल्ली की क्यों नहीं फंक्शन कर रही? स्टेट और सेंटर एक दूसरे से भिड़े हुए हैं. क्यों? क्योंकि सेंटर स्टेट को ब्लेम कर रहा है, स्टेट सेंटर को ब्लेम कर रहा है, पैसे नहीं दिए. तो वो एक अच्छी बात है एक्चुअली. नाउ आई गेट योर व्हाट यू आर सेइंग कि सेंटर, देखिए, सेंटर इज सपोज टू गिव फंड्स टू स्टेट्स. स्टेट्स आर सेइंग कि हमें तो पैसे ही नहीं आए सेंटर से, तो हम इसको भी नहीं देंगे नीचे वाले को, राइट? सो मे बी आई थिंक इन रीसेंट कॉन्टेक्स्ट वो कह रहा है ना, तो पॉसिबली दैट हैज टू बी डन. बट ये फिर चैलेंजिंग क्वेश्चन बन जाता है ये. बट फिर भी मुझे लगता है कि 4-5 पॉइंट तो लिखे जा सकते हैं अपार्ट फ्रॉम फंड फंक्शन फंक्शनरीज एज वेल, which we generally discuss जब हम पॉलिटी की क्लासेस लेते हैं, या फिर otherwise also whatever you would be coming across. आपने भी जो भी मटेरियल पढ़ा होगा, even if you haven't attended my classes or whatever it is, I'm sure you would have come across some other points which you can mention here, right? Anyway, let's move on to the next question. Parliamentary provisions पे बड़े क्वेश्चन पूछ रहा है ये. Now interestingly, see, when I cover, say for example in my polity classes, I don't touch upon issues with functioning of parliament, because I believe these are very simple things which you can do it on your own if you pick up any basic text, थोड़ा एनालिटिकल टेक्स्ट. जैसे विजन का वैल्यू एडेड मटेरियल आप उठाएंगे, उसमें आपको बहुत सारे कवरेज मिल जाएगी ऑन इश्यूज रिलेटेड टू द फंक्शनिंग ऑफ द पार्लियामेंट ऑफ इंडिया. और उस पे ये हर साल सवाल पूछ रहा है, कम से कम एक या दो. सो लेट्स सी सम ऑफ दीज क्वेश्चंस. अब ये बड़ा अच्छा क्वेश्चन था, पता है, बहुत अच्छा क्वेश्चन था ये. Rajya has been transformed from a useless stepney tire to the most useful supporting organ in past few decades. Highlight the factors as well as the areas in which this transformation could be visible. अब देखिए, दो चीजें हैं इस क्वेश्चन में. एक तो ये है that you must tell that earlier the Rajya Sabha was a useless stepney tire. And maybe you can't say that earlier or present, but what you can do is you can talk about constitutional scheme. How the constitution makers deliberately have made Rajya Sabha weaker. वो मेंशन कर सकते हैं हम. उससे एक स्टेपनी टायर का आइडिया प्रूव हो जाएगा. स्टेपनी टायर कब यूज होता है? जब मेन टायर फट जाता है. That is when you use the stepney tire, no? So earlier it was only supposed to be some sort of a check and balance on the powers of the Lok Sabha. Therefore it has not been given a lot of powers when it comes to budgetary matters. Even the representation of the Rajya Sabha in the committees of the parliament was negligible. For example, estimates committee में तो अभी भी नहीं है. Public Accounts Committee, earlier there used to be no representation of Rajya Sabha. It used to be a 15-member committee completely consisting of the members of the Lok Sabha only. So you mentioned about some of those things. Then next part is actually very important. Please read it carefully. Highlight the factors as well as the areas in which this transformation could be visible. तो पहले एरियाज सोचिएगा, फैक्टर्स अपने आप दिमाग में आ जाएंगे. What are areas of transformation? There are number of bills on which the Rajya Sabha has acted contrary to the Lok Sabha. A number of issues related to the concerns of the states have been raised in Rajya Sabha, which has not happened in the Lok Sabha. Then the quality of debates and discussions in the Rajya Sabha has been far superior, or maybe if you don't want to say that, has been of great quality because of the expertise that has come into the Rajya Sabha. You may talk about that now more and more ministers are coming from the Rajya Sabha. Ministers of central government are also coming from the Rajya Sabha. So ऐसे 3-4 areas of transformation हो गए. अब second जो बात है ना वो है सारा factors की. What has led to this? What has led to this? Governance has become very complicated. Lok Sabha alone with its layman character cannot deal with those issues of governance and legislation. Am I right? Can we say that as a factor for the increased role of Rajya Sabha? Legislation has become complicated. लोक सभा में लेमन पॉलिटिशियन आ रहा है, राज्य सभा में एक एक्सपर्ट भी तो आ रहा है. सेकंड, due to the increasing power of the regional parties, Rajya Sabha has become a chamber for the states to express their concerns and opinions. Yes or no? Can we say that also as a factor or not? Yes. Another thing is Lok Sabha is usually affected due to disruptions. In that case, Rajya Sabha has come in and filled that particular gap. That could be another factor. Or koi factor? Anything else? Very good. You may talk about that also. During the emergency, if the Lok Sabha is dissolved, then the Rajya Sabha can play a part in keeping a check on the emergency which has been imposed by the President of India. What else? What leader of opposition? So? What? So? नहीं, वो तो इंपॉर्टेंट रोल है, मैं फैक्टर की बात कर रहा हूं अभी. यस. Because of a majoritarian government in the Lok Sabha, the other parties are able to assert themselves in the Rajya Sabha because they see that as the only chamber where they can assert themselves. You may talk about possibly anti-defection law as well, which has affected the functioning of the Lok Sabha. But in Rajya Sabha, because it is a multi-party chamber to a large extent, there is no one single party. That reflects the character of the Indian democracy as well, of a multi-party democracy. Yes, sir. बिल्कुल ठीक बात है सर, एब्सोल्युटली करेक्ट. रीजनल इश्यूज, स्टेट लेवल इश्यूज आर बिकमिंग मोर प्रोमिनेंट टुडे विद डिसेंट्रलाइजेशन. इस तरीके की चीजों से आप रिलेट कर सकते हैं. ये अच्छा क्वेश्चन है बड़ा, क्योंकि उसने जब फैक्टर्स पूछ लिया ना, तो वो फैक्टर्स, अब क्या होता है कि कैंडिडेट्स लिख के आ जाते हैं बस अंधाधुंध, फैक्टर्स देखते नहीं, तो फिर नंबर नहीं आते. फिर बाद में आके जो है लोग, अब देखिए हो सकता है आपको ऐसे बहुत सारे टॉपर्स भी मिल जाए जिन्होंने खुद ही इसको इग्नोर कर दिया हो, मुझे नहीं पता, हो सकता है, बट कौन कहता है कि टॉपर से ज्यादा नंबर नहीं आ सकते? हु सेज दैट? कौन कहता है कि टॉपर कॉन्स्टिट्यूशनल एक्सपर्ट है या एकदम पूरा सारा कुछ सब कुछ जानता ही है पार्लियामेंट और पेपर 2 के बारे में? यू गेट द पॉइंट? टॉपर जो है आदमी केवल, मैं तो अपने सब्जेक्ट की पर्सपेक्टिव से बात करूंगा ना, देखिए टॉपर आदमी केवल एक सब्जेक्ट में मास्टर बन के नहीं बनता है, उसको सब सब्जेक्ट में इक्वली अच्छा करना पड़ता है, उसमें कई बार एक सब्जेक्ट में कॉम्प्रोमाइज भी हो जाता है। एनीवे, नाउ दिस क्वेश्चन, I hope that this is a simple question, right? I mean, this, अब तो ये बहुत बार हम थीम डिस्कस भी करते हैं, once a speaker always a speaker. Do you think that the practice should be adopted to impart objectivity to the office of speaker in the Lok Sabha? What could be its implications for the robust functioning of parliamentary business in India? So see, it says that once a speaker always a speaker. This is the practice which is adopted in Britain in order to maintain the neutrality of the position of the speaker. Once you become a speaker, then you cannot be removed from the position of this, you continue to remain the speaker as long as you are in active politics. That is what is the concept of once a speaker always a speaker in the British parliament. This one says that once a speaker always a speaker. Do you think that this practice should be adopted in India to impart objectivity to the office of the speaker of Lok Sabha? What could be its implications for robust functioning of the parliamentary business in India? अब दो चीजें हैं, एक कि क्या हमें ये प्रैक्टिस इंडिया में अडॉप्ट करनी चाहिए, और दूसरा इससे क्या इंप्लीकेशंस होंगी। अब पहली बात तो ये कि ऐसा क्यों करना है, न्यूट्रलिटी की वजह से। इसका मतलब क्या है कि कोई प्रॉब्लम है। क्या प्रॉब्लम है? स्पीकर की पोजीशन के ऊपर सवाल उठ रहे हैं बार बार कि न्यूट्रल नहीं है। सो यू बिगिन विद दैट ओनली। इन रीसेंट टाइम्स देयर हैव बीन अ नंबर ऑफ controversies or questions related to the neutrality of the position of the speaker. The speaker plays an important role in case of deciding cases related to anti-defection, deciding whether a bill is a money bill or not. He also plays an important role in some of the other areas as well. For example, क्या होते हैं और whether a particular member should be allowed to speak in the parliament or not, acceptance or rejection of motions, right? Casting vote, whether casting vote should be done or voice vote should be done. In money bill है ना, तो in many of these matters there have been questions that have been raised over the neutrality of the position of the speaker. Therefore some people suggest that we must try to make the position of the speaker neutral by adopting the British principle of once a speaker always a speaker. Explain that principle. Once you explain that principle of Britain, once a speaker always a speaker, एक बार आपने उस पर्टिकुलर चीज को एक्सप्लेन कर दिया, राइट, देन यू नीड टू गो फर्दर एंड यू नीड टू टॉक अबाउट दैट, सी what can be the implications of adopting this in India, but then you must also answer whether we should adopt this in India or not. Actually, to be very honest, in India you must mention that we already have a provision in anti-defection law. It is just a matter of convention whether we want to ensure the position of the speaker should be neutral or not. For example, under anti-defection law we know that na provision kya hai, if the speaker resigns from his or her political party after being chosen as the speaker of the house, then that person cannot be declared as disqualified under anti-defection law if he does not join his political party during the tenure of his office as a speaker or any other political party, or if after demitting the office he goes and joins back his own political party only. यही तो है। तो आप बोलिए कि ये एक्चुअली प्रैक्टिस अडॉप्ट हम कर सकते हैं, पर हमारे कॉन्स्टिट्यूशन में ऑलरेडी प्रोविजन है इसके लिए, तो मतलब हमें ज्यादा दूर जाने की जरूरत नहीं है। We just need to bring that practice into play, that's all. And maybe some other reforms can also be introduced to make the position of the speaker neutral, or to take away some of these powers away from the position of the speaker. Money bill or no money bill, we can adopt the practice in UK, जहां पे committee होती है. Whether anti-defection law, we should give these powers to the Election Commission of India, an independent constitutional body. तो इस तरीके की चीजें आप mention कर सकते हैं. Is that clear? Right? Let's look at one or two more questions possibly. Parliamentary functioning पे देखिए, ये तो बहुत ही simple question था, है ना, मतलब इसमें बिल्कुल सिंपल. डिस्कस रोल ऑफ वाइस प्रेसिडेंट ऑफ इंडिया चेयरमैन ऑफ राज्यसभा. अब इसमें बस इंटरेस्टिंग बात ये कि आप इसको थोड़ा सा अपना आंसर अलग कैसे करेंगे, वो है बस इसमें चैलेंज. थिंक अबाउट इट. एनीवे, ये वाले क्वेश्चंस भी बड़े आने लगे हैं आजकल. कॉन्स्टिट्यूशनल बॉडी दे देता है, ह्यूमन राइट्स बॉडी दे देता है, और फिर वो पूछ लेता है कि उसका स्टैट्यूटरी बॉडी से कॉन्स्टिट्यूशनल बॉडी होने पे क्या फर्क पड़ेगा. विच स्टेप्स आर रिक्वायर्ड फॉर कॉन्स्टिट्यूशनलाइजेशन ऑफ अ कमीशन. डू यू थिंक इंपार्टिंग कॉन्स्टिट्यूशनैलिटी टू नेशनल कमीशन ऑफ वुमेन. एक ही सेम सवाल है, कुछ नहीं है डिफरेंट इसमें. इन दिस व्हाट यू जस्ट नीड टू थिंक इज दैट सी constitutionalization of a body essentially leads to elevating its status from a statutory to a constitutional body. So there is a general rise in prestige and power of that body and in the hierarchy of that body as compared to the other functionaries. Other thing which it also does is that now that we have mentioned the functions of this body in the constitution itself, it gets certain protection which cannot be changed by a normal ordinary law of the parliament or the state legislature. The third thing which it does also is that now since it's a constitutional body, its members will also enjoy certain kind of independence from the control of the executive and the legislature. So उस तरीके की आपको चीजें लिख सकते हैं. प्लस व्हाट आर द फंक्शंस दैट आर सपोज टू बी परफॉर्म्ड बाय एनसीबीसी, नेशनल कमीशन फॉर वुमेन, सेम थिंग मोर और लेस. सो इन दिस आल्सो इफ यू सी, when I, for example, some of you are my students, when I discuss constitutional bodies, I tell you very clearly that please don't, there is no need to break your head over this. That हर constitutional body के members याद कर रहे हैं, basic सबके functions याद कीजिएगा, उस सब पे एक जगह लग जाएंगे, और बेसिक सबकी एक ब्रॉड आइडिया ले लीजिए कि इनकी फंक्शनिंग में क्या प्रॉब्लम्स है. सबकी फंक्शनिंग में सेम प्रॉब्लम्स है. रिकमेंडेटरी बॉडी है, इनके पास खुद की इन्वेस्टिगेशन मशीनरी नहीं है, शॉर्टेज ऑफ स्टाफ है, फंड्स की जो एक मैसिव प्रॉब्लम रहती है, बहुत सारी केसेस में लिमिटेशन पीरियड भी है, दैट दे कांट टेक अप केसेस फ्रॉम द पास्ट. जैसे एनएचआरसी के ऊपर लिमिटेशन पीरियड है 1 साल का. Right? Those are the kind of issues that you can mention. Often the states and the center do not cooperate in investigation. The recommendations which they give are often ignored. The reports which are tabled in the parliament are not discussed extensively. Same problems है. But वो अब देख लीजिए आप, इस और इस क्वेश्चन में कुछ ज्यादा फर्क है नहीं एक्चुअली, बस बॉडी चेंज कर दी, बात एक ही है. There is not much which has changed in this question as such. Is this clear to everyone? Let's discuss probably 1 or 2 questions more. मैं बार बार एक दो और कह रहा हूँ, but let's look at, ये तो बहुत ये गति शक्ति योजना एंड ऑल दैट. अच्छा, इससे ना एक चीज और आती है. अब देखिए, दिस क्वेश्चन विच वाज आस्क्ड, गति शक्ति योजना नीड्स मेटिकुलस कोऑर्डिनेशन बिटवीन गवर्नमेंट एंड दिस थिंग, दिस काइंड ऑफ पॉइंट्स दैट मे बी यूपीएससी इज इंक्लाइंड टू आस्क क्वेश्चंस ऑन schemes and policies as well. One second. Schemes and policies as well. Okay. So just pay a bit of attention this year if you're writing the mains examination. Because last year this question just did prove to be bouncer for some, but मैं हमेशा ये भी कहता हूँ कि इंडियन एक्सप्रेस एक्सप्लेन करके जाइएगा, ढंग से प्रिपेयर कीजिए उसको. स्ट्रेट अवे उसी से क्वेश्चन आया था इंडियन एक्सप्रेस एक्सप्लेन से. एनीवे, बहुत फैक्चुअल क्वेश्चन था, सो आई डोंट थिंक, प्लस एक एक्चुअली न्यूज़पेपर एडिटोरियल भी आया था. सो इंपॉर्टेंस ऑफ न्यूज़पेपर, राइट. देयर वाज अ, ये भी मैं एक चीज हमेशा बोलता हूं कि जब भी प्राइम मिनिस्टर, प्रेसिडेंट, चीफ जस्टिस कुछ भी बोले, पे अटेंशन टू इट. स्पीच ऑफ प्राइम मिनिस्टर, प्रेसिडेंट, चीफ जस्टिस, वाइस प्रेसिडेंट should be given importance. हमेशा, always. If the leader of the nation is saying something, you of course need to pay attention. And UPSC has propensity of asking questions on that. Right? Anyway, ये तो last year का कुछ है. वही कहीं से उठाया था UPSC मीम से. Anyway, so e-governance related question. Reforming the government delivery system through the direct benefits transfer scheme is a progressive step but it has limitations to comment. Very standard question, very standard question. You talk about the benefits of DBT, but you talk about its limitations as well. What are the limitations of DBT? Exclusion, inclusion, identification of beneficiaries itself can be a problem. Most people, and see the other thing with DBT is, at least अगर जैसे पहले राशन शॉप होती थी तो मेरे को राशन तो मिल जाता था. अब डीबीटी में प्रॉब्लम यह है कि पैसा तो आ गया, अब मैं कहां जाऊं राशन लेने? Where do I go? I'll have to go to the retailer only, and there I can't do any quality control. That is one problem which is there. There is always another problem which is there. Limitations, which is that people may end up spending that money on frivolous things. आदमी लोगों के अकाउंट में गया तो वो तो रोज रात को सारा राशन बच्चे का एक रात में पी गया वो. पूरे घर का राशन जो है एक रात में पी लिया उसने. इक्विवेलेंट ऑफ दैट. और क्या प्रॉब्लम्स हैं? Okay, so there may be issues with respect to verification of whether it is actually reaching the intended beneficiary or not, even though we are doing all the sanity check, but there is always a possibility that things may get lost in technology as such. What else? और क्या है? Absolutely. So there are other problems as well. Elite capture of power by some of the dominant communities in the local areas, because of which the benefits do not actually reach the intended beneficiaries. They keep these benefits for their family members, etc. And the funds, often funds remain underused or underutilized as well. Yes, what else? आधार आइडेंटिफिकेशन, वही जो हमने बायोमेट्रिक आइडेंटिफिकेशन एंड एक्सक्लूजन एक्सेट्रा की बात की थी. और क्या हो सकता है? मैंडेटरी आधार in a, you are again putting it contingent on whether person has. अच्छा, दूसरी चीज में आप ये भी तो लिखिए, डीबीटी के लिए भाई उस आदमी के पास बैंक अकाउंट भी तो होना चाहिए, और उस आदमी के पास बैंक अकाउंट के अंदर कितना पैसा है कितना नहीं आया चेक करने के लिए इंफ्रास्ट्रक्चर, मोबाइल कनेक्टिविटी भी तो होनी चाहिए. राइट, देयर इज अ बिग प्रॉब्लम. आप रूरल एरियाज में जाएंगे तो लोगों के पास इंटरनेट, देखिए अभी हमें यहां देख के बैठ के बहुत अच्छा लगता है सब कुछ, बट अवेयरनेस की भी तो बात है. पीपल आर नॉट अवेयर, पीपल आर नॉट डिजिटली लिटरेट. उस आदमी का क्या, पहले उसको कम से कम ये पता था कि मेरे को अपना फिजिकल कार्ड दिखाना है, जाके मुझे ये मिल जाएगा. कभी सर्वर डाउन है तो फिर क्या, वेगरीज ऑफ टेक्नोलॉजी. डेटा क्रैश कर गया, सर्वर क्रैश कर गया, आज मत आना कल आना राशन लेने. फिर वो कल गया, आज भी सर्वर डाउन है, परसों आना. आई एम जस्ट सेइंग, राइट, डीबीटी ट्रांसफर के अंदर दैट प्रॉब्लम कुड आल्सो बी देयर. Anyway, so relatively again simple question, and there were a number of questions, number of editorials which had come related to this. For example, there was this one: the benefits are long term compared to the short lived happiness of freebies. Right? CAG report picks holes in the DBT performance audit. Then after conducting review of the beneficiaries in accordance with Punjab government instruction, the department found that 70,000 beneficiaries ineligible under 4 social security schemes, pointing out recovery of almost 162 crores. Right? So those kind of things need to be also mentioned. Ensured efficiency leads to targeted beneficiaries, makes governance more effective and efficient, etc. Slow onboarding of schemes, lack of infrastructure, lack of political will, lack of human resources, deprivation of benefits. जो मैं कह रहा था आपको, डीबीटी की पेमेंट जो है वो पेंडिंग है. डीबीटी करने से थोड़ी ना मतलब लोगों के अकाउंट में पैसे चले जाएंगे. गवर्नमेंट को पैसा रिलीज भी तो करना पड़ेगा कभी. देयर इज अ डिले इन रिलीज ऑफ फंड्स आल्सो बाय द गवर्नमेंट फॉर गवर्नमेंट स्कीम्स, स्पेशली जो सेंट्रली स्पॉन्सर्ड स्कीम्स होती हैं. सेंटर स्टेट को तड़पा देता है एकदम बुरी तरीके से, तड़पा के मारता है सेंटर स्टेट को. When you will go into states you will realize that, because आप लोग सिर्फ सेंटर के ऑफिसर्स थोड़ी ना बनोगे, यू विल बी ऑफिसर्स ऑफ द स्टेट्स एज वेल, राइट? एनीवे, emergence of fourth industrial revolution has initiated e-governance as an integral part of government. Discuss what, so it's saying that first you have to explain what is digital revolution, and now government is also using more and more of e-governance mechanisms to deliver services to the government, to the people. That is what the gist of this question is. E-governance के लिए मेरा suggestion ये रहेगा आपको that you refer the second ARC report's recommendations on e-governance. Not the entire report, just refer the recommendations, make a note of them in your own language, and on the basis of those recommendations, down some of the problems as well. Or you may just simply alternatively refer the value added material of Vision IAS. जितना भी वो 100 पेज का मटेरियल है गवर्नेंस के लिए, I think that is enough. You don't need to go beyond that. बट ई गवर्नेंस स्पेसिफिकली क्वेश्चंस गोल गोल घुमा के बात एक ही करते हैं. इस क्वेश्चन में भी अगर आप देखोगे, हैज डिजिटल लिटरेसी पर्टिकुलरली इन रूरल एरियाज कपल्ड विद लैक ऑफ इंफॉर्मेशन एंड आईसीटी hindered socio-economic development, examine with justification. Question asked in 2021. So you have to talk about that, yes, we have introduced a number of ICT based schemes, etc., but digital literacy and digital divide is a massive problem. You give some examples of that. अच्छा, इसके ऊपर भी let me just quickly discuss, then we'll call it a session. अभी और भी बहुत सारे questions हैं, but अब we have kind of run out of time. I think there was only one way. Either I could have focused on quality or I could have focused on quantity. Now, this one, it says that अब ये ROPA से related जो चीजें हैं, ये कैसे prepare की जाए? Firstly, एक बार ROPA download कीजिए. Please see what are the important chapters in ROPA. In that, I would suggest that you have a look at the chapters related to disqualification under ROPA, chapters related to corrupt electoral practice under ROPA, chapters the provisions related to the ROPA में ये क्या है, the electoral expenses, election expenses, etc. under ROPA, and the disputes under ROPA, election petitions and disputes. That is what you should focus on. Other than that, I am also, मैंने almost 4 महीने पहले बोला था students को that I am working on a handout, but I have still not got time. But when I do, I ensure that it will be done before mains examination this year. When it is done, I'll share it. I'll put it on my Telegram group also. You can get it from there because I know ROPA के ऊपर genuinely अच्छा content नहीं है. और जो भी content है इधर उधर से रद्दी copy करके बनाया हुआ है कुछ लोगों ने. So I'm trying to work on that, but somehow I've not been able to get a lot of time. Maybe in next 15 days, I'll be on a break, so I'll be able to, in 15 days I'll be on a break, so possibly I'll get some time to be working on that document. So ROPA related questions, if you see this question that was asked that discuss the procedures to decide the disputes arising out of the election of a member of the parliament or state legislature under ROPA, this question was framed strictly out of Indian Express explained article and newspaper articles. So there was an Indian Express explained article जो exactly यही सारी कहानी बात कर रहा था. तो न्यूज़पेपर में अगर ROPA से रिलेटेड कोई न्यूज आ जाए या कुछ आ जाए तो झट से उसको पकड़ लेना एंड उसके नोट्स बना लेना, बिकॉज उस बहुत ज्यादा इसके अंदर स्कोप नहीं है यूपीएससी. बिकॉज अगर वो एक ऑर्डिनरी लॉ की डिटेल्स में जाके पूछना लग गया तो देन देयर इज नो लिमिट टू इट, राइट? सो जस्ट हैव अ लुक एट इट वंस. एंड देन देयर वाज अनदर क्वेश्चन दैट वाज आस्क्ड, देयर इज अ नीड फॉर सिंप्लीफिकेशन ऑफ प्रोसीजर फॉर डिस्क्वालिफिकेशन ऑफ पर्संस found guilty of corrupt practices under ROPA. Comment. Actually, the simplification of the procedure is required because if you are guilty of corrupt practices under ROPA, the procedure is really complicated. First, there is a representation that has to be made in the High Court, then the High Court gives the order, then once the High Court gives the order, then the order goes to the President, then the President consults the Election Commission, and then the disqualification order is made. And plus on top of that, there are certain provisions through which you can seek exemption also under this. For example, the Election Commission of India can do away with your disqualification if it wants. So therefore it says that there is a need for simplification of this procedure, which means that instead of it going to High Court, then going to President, then the Election Commission and all of that, we need to simplify this procedure a bit. But जब आप इसकी बात करें, simplification is required, you must also mention that this simplification we must also keep it in mind that oversimplifying it would also reduce the checks and balances which exist in the present system, which need to be retained. So you may talk about some of those matters. Anyway, I am working on this particular document and I'll share it with those of you who are my student. You will get access to it anyway. Those who you're not, I'll put it on my Telegram group. You will get it from there as well. So you can just have a look at it there. Right? So, और भी करेंगे डिस्कस? हाँ, बहुत सारे क्वेश्चंस हैं यार. चलो एक क्वेश्चन और देख लेते हैं. Let's possibly maybe look at this question. Or maybe let's look at this question. Analyze the distinguishing features of the notion of equality in constitutions of India and USA. Both Indian Constitution and American Constitution have talked about the right to equality, but in a different manner, and both of them evolved in a different context as well. In case of America, firstly, the original Constitution did not include the principle of equality. Ours did. Secondly, even in the preamble, originally the idea of equality was not mentioned. And not only that, you must understand that, see, the reality is that the Americans never considered all the Americans as equal. Slavery was abolished only as late as 1861. The voting rights were given to women only as late as 1920s. The full civil rights were given to the blacks only as late as 1960s. Whereas in India, we took the leap of faith to provide equal rights to all the citizens, irrespective of their religion, race, caste, sex, place of birth, any of these things. So that itself is a big difference. For us, equality was very important because of our freedom struggle, because we had been treated unequally. For the Americans, it was not such an important thing because that entire nation was born on the idea of inequality. Slave trade नहीं होता तो कहाँ होता अमेरिका? अगर इंडेंचर्ड लेबर नहीं होती उनके पास, जो अफ्रीका से भर भर के लाए जा रहे थे इतनी atrocious conditions के अंदर, how they would have been able to carry out their industrial production, or how the plantations would have worked in the southern states in America. So that is one thing. Second is that the Indian Constitution, the idea of equality is very broad. It not only includes generally equal protection of laws ka idea, but it also talks about abolition of untouchability. It talks about abolition of titles. It talks about the equality in matters of employment as well, because in India there was always a discrimination in matters of employment as well with respect to your caste, religion, etc. We have included in the Indian Constitution the idea of equality in terms of access to public places as well, which is not there in the American Constitution. Again, because of our history. So again, a differing idea of equality. इतनी सारी चीजें हैं इस क्वेश्चन में लिखने को. You can also talk about that the American Constitution only talks about equal protection of the laws, but we also talk about equality before the law. So we say that there should be equality between people placed in equal circumstances, and unequal circumstances placed people should be given special treatment. And you also talk about that in Indian Constitution we have explicit provisions, 15.3, 16.4, 15.5, 16.5, which are allowing the state to make special provisions in favor of the backward classes of citizens, especially socially and educationally backward classes of citizens, in fact even women. और हमने इंडिया में इक्वालिटी को इंप्लीमेंट किया है रिजर्वेशंस के थ्रू, कोटा बेस्ड रिजर्वेशंस. America, on the other hand, has affirmative action, but the affirmative action in their nation is not in form of quota or reservations. It is that the policy of the state will try to promote certain sections, will try to promote certain downtrodden sections, but there is no explicit commitment which has been made, right? Our policy is very different from that. So those are the ideas of equality, of how they differ in India as compared to America. बहुत सारी चीजें हैं. अगर आप केवल आर्टिकल 14, 15, 16, 17, 18 को ही एक ब्रॉड आइडिया दे दें और बोल दें कि अमेरिका में इसके काउंटर पार्ट कुछ भी नहीं है, that itself should be enough. Plus on top of that they included the idea of equality by 14th amendment. Ours was already there. They took such a long time to abolish slavery. They took such a long time to give voting rights to women. We gave voting rights to everyone. There was no inequality. We in fact abolished slavery and forced labor in the constitution itself, article 23. They did not do that. They took a long time. They had to fight a bloody civil war and lose a president, and then they were able to overcome this entire thing. और ये कहीं ना कहीं सच्चाई है that the Americans never treated blacks as equals. उनका कॉन्स्टिट्यूशन इस बेसिस पे था ही नहीं इक्वालिटी के आइडिया पे. हमारा कॉन्स्टिट्यूशन इक्वालिटी की बहुत पुरजोर बात करता है, जस्टिस की बात करता है. और हम ये भी बहुत बोलिए कि हमारे यहाँ पे इक्वालिटी मीन्स जस्टिस, गोइंग बियॉन्ड ब्लाइंड इक्वालिटी, इक्विटी एंड जस्टिस, creation of such conditions in the society that everyone should come at the same level. Therefore DPSPs में भी equality की बात हुई है. Social and political equality से बढ़ के social and economic equality की भी बात हुई है DPSPs में. So you mentioned that also. That should be enough, right? Any questions? See, I'm calling it off here. I mean, I know that there is a lot to discuss, but I am out of energy now. I can't do more of this. Yes, any questions, any doubts that you have? Okay, thank you so much for attending the session. Wishing you all the best. If you want to see the specific discussion, what I would suggest is that you may refer the discussions on our YouTube channel only for previous year questions. वहाँ पे मैंने एक question को ज़्यादा detail में discuss किया है, rather than today. Of course, we couldn't do that. But you will find the analysis for 2020, 2021 and 2022, all three of them on the YouTube channel. Right? Thank you so much.